Meet please, your lordship.
Yes, Mr. Lal.
Lordship, I beg to mention item number 11, my lord. With the consent of the other side, my lord, can it be taken up on 11th of March, my lord? I have some personal difficulty today, lordship.
You inform the other side.
We have informed, we have taken permission, my lord.
When do you want?
11th of March, lordship.
11th of March.
Lordship.
11th of March would be a Wednesday. Have it on a Tuesday or a Thursday?
My lord,
It's
I
a
already
DPD.
have a lordship. I already have a matter on Thursday, my lord.
It's not a designated. It's not a designated DPD.
Lordship.
Either you have on 10th or 12th. 12th.
12th, lordship. Then lord, 12th of March.
A request for adjournment has been made by Sri A. Lal appearing online for the petitioner. Para. Matter is accordingly adjourned to be listed on 12/3.
Lord.
For hearing.
I'm obliged, my lord.
Item number 1.
Yes.
Lordship, the respondent has
You are supposed to have some
made an
instructions on the
objection.
maintainability part.
Yes,
You have got the instructions.
yes, my lord. Maintainability we have raised in the repetition also, ma'am, at the time.
Now, even in the aspect of the appeal,
Yes.
you had raised an objection.
Yes, yes,
If you are ready, we can hear you on the maintainability.
yes, ma'am.
Why is the question on maintainability?
My lord, basically the repetition, it was filed for
Are you ready for the matter?
Lordship,
Yes.
deletion of names from the electoral rolls.
Okay. They were asking for the deletion.
Deletion of name from the electoral rolls, Panchayat Raj electoral rolls from Vijayanagar circle, ma'am.
Hmm.
Now, none of the persons who are sought to be deleted, they have been made parties.
Oh, they wanted somebody else's name to be deleted.
They wanted the
Okay, somebody else, not their names.
Yes.
That is what we are asking.
yes,
They were agreed by the inclusion of names in the
electoral roll,
and those persons have not been made part.
not been made parties.
Yes. On that ground, the petition has been dismissed.
Yes, my lord.
How do you overcome this?
Lordship,
The basic rules of principles of natural justice. Some action will be taken against individual. You have not made them party.
Lordship may consider and let the applicant make a let them implique the respondent.
At this stage, appellate stage, we are in intra-court appeal. You have to plead in the writ petition. Writ petition has been dismissed.
Lordship, the grounds that the lots of
Was any liberty granted to you?
Lordship,
File afresh. Liberty is also not there.
the lords, there are more than 3,000 to 4,000 respondent, Lordship, in that case.
In matters of this nature, you can go for a paper publication. There are avenues that anyone aggrieved can get itself impleted. That was not your prayer. Not
Lordship,
the first time that this kind of matters are being adjudicated.
Yes.
Where number of affected persons can be more than 1,000.
Lordship,
So in that case, you may have a genuine difficulty in making all of them a party. But it has to be properly structured. There has to be a paper publication about this litigation.
And my lord, on top of that, my lord, there is a procedure for inclusion or deletion of names in the electoral roll. my lord. There is a process. There is a rules conducted. And
Did he take any of the? Did he take?
he has not. He has not.
You can
Lordship,
report of
Lordship,
that.
I have submitted the representation also.
No,
I have-
presentation is not the procedure.
Yes, I have made objection in the Form 5 also, Lordship. There is a provision that we can make an objection in Form 5. And as well, I have made the objection also.
What is the outcome?
Outcome is that they have never entertained our objections. In fact, there is procedure that we can make an objection. And accordingly, I have made objection. But it has never been considered, Your Lordship.
What is your prayer?
My prayer is, Lordship,
In the repetition, let us see your prayer in the repetition. You come to page 69, 68. This is your prayer, isn't it?
Lordship. Lordship, here the non-APST settlers in Vijayanagar, they have been described as the ordinary residents. But then there is a notification, Your Lordship. And the same
What is your name?
Titatak.
D Tatak. Okay, Mr.
Tatak.
Just a word.
Lordship, there is a
Just a
notification.
word. Just a What is the finding of the learned civil judge?
The finding of the civil judge's Lordship, he have considered them to be the ordinary resident.
No, let us see. Where is the finding? Page?
Lordship, may please come to page number 31.
See, Mr. Ratan, come to the paragraph 18 of the judgment, impugned judgment. The writ petition has been dismissed not only on the issue of non-joinder.
Yes, my lord.
The learned single judge has touched upon the merits. If you come
Then,
to paragraph 18,
Para 15, it's it has referred to the non-gender of parties, my lord.
come to the conclusion part,
Yes.
paragraph 18, where the conclusions have been summarized. The first is on merits, second is on non-gender of parties, and third is that it would be in violation of Article 243E.
Yes, my lord. In fact, there was a prayer for non-holding of elections also. Apart from this deletion of names and for non-holding of election. That's why violation of Article 243E.
Okay, we will issue,
Your Lordship,
we'll issue notice.
Lordship, it was
We'll issue
considered.
notice, Mr. Tata.
Lordship,
Issue notice. Heard Sri T. Tatak, learned counsel for the petitioner, for the appellant, who appellant is the society
Lordship.
who is aggrieved by the judgment, by the order dated 11/11/2025, passed in WPC so and so. The said writ petition was dismissed on the motion stage. Full stop para. The learned counsel has submitted that apart from the aspect of non-gender of necessary parties, which was taken into consideration, comma, the impugned order has also touched upon the merits of the challenge. He has also emphasized that the principal ground of filing the writ petition was with regard to inaction on the part of the authority to take action, to take steps on the representations of the petition of the appellant petitioner towards preparing a correct electoral rolls for the panchayat election. Para. that notice be issued. Returnable on, yes, when?
3 weeks. Sir.
We give a date, returnable on 24th of March. 24th of March. Mr. Ratan will be having for whom? 1, 3, 4, 5, 1, 3, 4, 5.
1, 3,
4 and
Four.
5.
5.
4 also
Yes.
perhaps.
Yes, 4
Four.
and 5.
And Ratan. And Ms.
And
Anju,
For 2 and 6.
2 and 6 extra copies. Okay. Let us see.
My lord, the issue on the maintainability maybe kept open. My lord.
It is there, we're not saying anything, we can still argue. We're just issuing notice.
If that observation is made, otherwise,
No, maintainability is a ground of challenge only in the writ petition.
yes, sir.
It will have to be non-maintainable. So the question of maintainability of the appeal will not arise separately.
Okay.
Yes.
Item number 2.
One of this PIL pertains to the, my lord, tardy execution of the
Why is it for orders today?
my lord, they are supposed to file their status report.
As per the last order.
Yes. And the Advocates Commission was also supposed to furnish a report.
This pertains to which
This package B, my lord, Papunala to Nirjuli, my lord, the word that we wrote that we use as every day.
yes, yes.
The order is dated 22/1/2006.
Yes, yes, we're, that's a matter of immense public importance.
Yes, my lord, this project was to be completed on 7th of December 2024. There's a flyover section also, my lord. There is 149 pillars. Only around 88, my lord, semi-constructed. That is how the work is being,
Yes,
that is the
yes,
progress.
Then what is going on?
my lord, and before my,
We're really concerned. What is going on in this?
My lord, we are also fed up with the contractor now.
You take steps against the contractor.
My lord, yes, my lord.
What we have seen for
That-
the last 6 years,
Yes.
there is no improvement.
yes,
The deadline is now 31st of July.
Is
And
it going
it
to be
is
over by 31st of July?
that
We
that
cannot
is
shut
now
our eyes to
impossible.
what
my
is
lord.
happening.
Yes, my lord. That is now impossible. My lord, we may be given liberty to take
What
it.
liberty? You are the owner. Where is the question of liberty? You take
But,
steps in accordance with law.
My lord, that observation may be otherwise what happens that
But what is the department doing?
on the last occasion also we had prayed for giving us the liberty to take appropriate steps against
Why is the
the
liberty required? Tell us.
my lord, since some directions are given
We don't want
To-
the liberty to be misused.
no my lord,
You take action in accordance with law. And it has got nothing to do with the PIL. Otherwise also you are entitled. If the scheduled date of completion was 7/12/2024, year and 1 year and 3 months
yes
almost
my lord. And
have passed.
Yes.
What was the period of completion? How much?
3 years.
3 years.
3 years
11 kilometers only.
7/12/2024 was the initial.
Court will not run the administration.
Yes,
It is your domain.
yes.
Yes my lord.
Well, the
Only
work
that-
started only after this PIL was filed. There was nothing going on before that. I
Every
don't
time
know.
some order has to be passed to the
Yes.
PIL for some movement, then we could see at one point of time, because of one order,
Yes.
something was done,
Yes.
tangible,
Mm.
where traffic movement was
Mm.
rerouted. Now we don't see anything.
My lord, the difficulty is that there are some orders whereby this honorable court is directing the contractor to go ahead with the work. And in the meantime, we are also contemplating to take action against that. That might be
Mr. Dubey, you're for whom?
I'm for the private respondent.
Contractor.
Yes.
What are you doing?
Lord,
What are you doing?
in fact, the progress has been slowed, my Lord, and Lord,
Before my lord, may I just point out, my lord, one thing, my lord, what is happening? Initially, during the summer period, the ground for the study progress, it was rain, then finance. Then on 26/9/2025, your lords, you will see the order itself is recorded. Finance are now available. Now, on the last occasion, there was some, now they're fighting between themselves, the contractor and the government. They are saying the government is not paying all these things. That is how it is going on, my lord.
Lord, we have also raised our concerns, my Lord. So it's not that, Lord, in fact, my Lord, our payments have been withheld, my Lord. That is also one of the ground, my Lord, why the progress could not be made substantially. My Lord, another important aspect which here I highlighted, my Lord.
Where have you stated that your finances have been withheld? Have you filed your affidavit?
Yes. Well, that's what, Lord, in last order, my Lord, your Lordship has directed to the state respondents, my Lord, to file a response to that, my Lord. But I am told my friend has filed an affidavit that copy has not
No,
been provided. to-
we have seen exchange of pleadings have gone to a large extent.
Yes.
The order sheets will be more than the pleadings.
My Lord.
Yes.
So many orders have been passed. There is no progress. This cannot go on like this.
But we also understand, Lord, of course, my Lord, I am also an officer of the court, Lordship. Lord.
You cannot allow this Nahalagun or Itanagar connection to be at this stage.
Yes.
For the last 7 years, it's nothing like this. There's no progress.
Lord, we have also raised an issue as regard, my Lord, handing over of the entire land, Lord, because if your Lordship sees that 3 years, my Lord, it's in fact is correct, my Lord. If one sees from the date of agreement and all, my Lord.
See, Mr. Dubey,
My
there
lord.
may be some issues in progress, but those
lord.
issues are required to be sorted out between the parties.
Lord, we have also,
We are concerned, the
I'm,
public is concerned with the completion of the work in time.
I bow down to your Lordship.
At times, there may be some difficulty,
Yes.
some delay for genuine reasons, but these are very, very normal reasons. In every work, there will be this kind of hurdles. But it cannot extend. And see, what is the nature of the work? It's in the heart of the
Yes, my Lord.
city, is the main connection.
They-
Every day, people are facing harassment. I'm not talking about the court or the lawyers or the judges. The normal people, they are
Yes,
facing so much of harassment.
2 months, my lord,
Look at the
SDCG
plight
will
of
start.
patient who needs to come to the hospital in
Exactly,
time.
my lord.
Somebody who wants to go to the railway station in time.
Yes. Somebody fell into a pit and died also, my lord.
This is not going to happen like this. Yes, what do you talk out? Your officers are there?
My Lord.
Yeah, not your contractor. Mr. Ratan, your officers are there in the court?
Yes.
Yes, what do they think? What plan do they have? Yes, please ask them to come.
But, may I submit, madam? On the last occasion, they have started taking a plea that we have started withholding their payments, madam. And they have also taken the plea that the land was given only in the year October 2025, the complete land. Now, this PIL started long back in the year 2024. These issues were never raised, madam. Now, after,
No, we are not on those.
yes, madam. Now they are.
What is the
they-
action
they-
plan? Action plan you are having to have the work done. Yes? What is your name?
Sir, Tajang, it's Tajang, sir.
Okay, you are posted as what?
Yeah, executive engineer. Nalak.
Yes, what do you think about it? How do you
Yes, sir.
complete this matter?
Yeah, my lord. Yeah. Last October 2025, we had issued an cure period because of the critical slow performance by the conductor, and we had given 2 months to cure the periods defaults. And on December 17th, that the time expires. So we were intending to issue an intention to terminate this one contract, but then this honorable court and dated 22nd January, authority was instructed to put on hold whatever further actions we were deemed to take, sir.
Where is the put on hold order?
Yeah, 22nd December order is there.
Where, Mr. Ratan, where we don't find which part?
The second day is no
22nd.
order, Lord, just because the personal appearance.
Yeah, it was there.
24th is an order by.
Yeah, the 24th, subsequently 2 days, 24th came,
24th
Sir.
is a detailed order.
24th September.
December.
December.
Okay.
उधर नहीं है, उधर यहाँ पे
In the order.
For December.
yeah.
Oh,
वो the board check
Is there any restraint order?
No.
No restraint order.
is एक बटन this उधर कुछ होगा
Was an observation that
so authority had pleaded this honorable court to allow us to take that, but that we were restrained. Not restrained exactly. I'm saying.
My lord, their apprehension is the since this honorable court has been directing the contractor to speed up with the work. So any termination may be in violation of this honorable, that is their apprehension.
No, their apprehension is something else. And or there being an order of this court is something else.
That is what they.
See, you have said that you have given extension up till July, 31st of July, 2026. But the present progress, can you ascertain from the present progress that the work would be over can be completed by 31st of July?
Impossible, man.
It's not possible.
It's impossible. So up to the
Mr. Dubey, is it possible?
No. I have also taken it, sir. It's not possible.
Even if everything is made available to you, is it possible?
The tools and machineries, my lord, we have personally checked. There are only three, I don't know what to call it, shuttering. There are 149 meters. Pier caps. I made a count myself as a layman. It takes around 5 years.
Perhaps that calculation is not.
No,
No, he may have a point,
Yes.
He has a point.
Mr. Tanging may have a point and he has a point.
I'm not. He
It's
has
as a
point, not
practical
Yes, there are
we have seen last how many years?
Three pier caps, my lord.
He does have.
There are 149 piers. Just a moment. There are 3 pier caps. That is admitted. If they say they have more, I will be very happy. There are 3 pier caps. There are 149 piers. Only 88 has been done.
number 14. Prayer.
ordered it. In the order dated 24/12/2025.
My lord,
What we propose
Right.
is that things are not going to work out in this manner.
yes.
31/7/2026
It's
is
not
a
possible.
dream, nothing is going to happen. And this is also an admission by both the parties.
Yes.
We'll give liberty to the department
Yes.
to take action
Yes.
for maintaining quality and for expeditious completion of the work. What you do, department, it's after 2 weeks, we are having the matter again to come back and tell us what you have done.
Right.
Okay?
Done.
Third,
Can I make one submission?
yes,
But there are two parts of it.
we are not asking
Yes,
the
yes.
department, we are not asking the department
Yes,
to
yes.
terminate the work. We are asking the department to take action in accordance with law to ensure that the
Madam.
work is completed in time
My lord.
and to maintain the quality. That's all.
Right.
Third, the Pami Learned Counsel for the petitioner Also heard Sri N. Ratan, learned AEG for the state. Full stop. Sri R. Dubey, learned counsel has appeared for the
Respondent number
respondent
7.
7. Full stop. Para. This writ petition in the nature of a PIL was instituted in the year 2024, mainly with regards to the delay in construction of the 4-lane road from Itanagar to Bandardua,
Yes, my lord.
Bandardua, section of NH 415 from kilometer so and so, huh?
Package B, my lord.
Package B.
Papunala to New Delhi.
Yeah, and package, where is the package? You have to write, huh? From package B. Package. Full stop. This matter has come up for consideration on numerous occasions, and this court, wide and order dated 24/12/2025, had recorded that the work has to be completed within 31/7/2026, beyond which no extension is required to be given. Full stop. It will be mentioned that the original date of completion, that the scheduled date of completion was 7/12/2024. And from that date, more than a year has passed. Full stop. Para. On a specific query made to the learned counsel for the department, along with the officer who is present, as well as Sri Dubey, the learned counsel for the respondent number
7.
7, a response has been given that it will be practically impossible to complete the work by the scheduled deadline, extended deadline of 31/7/2026. Full stop. Para. Taking into consideration the aforesaid facts and circumstances and the importance of the matter, which touches the interest, which has immense public, which has got immense public interest, this court is of the opinion that the department be given a liberty to take all further steps for timely completion of the work by ensuring that the standards are maintained. Full stop. The action taken by the department are to be apprised to this court by the next date. Full stop. Let's list this case on. We give you 2 weeks time. Today is 11th. On 25th,
Man.
Would it be on 27th?
27th.
But I have one prayer, Lord. Lord, there are issues from our end also, Lord, which we have highlighted.
Take it up. with
Yes,
the
Lord, that liberty also your Lordship may give us that, because we have raised our issue that has not been addressed by them, Lord.
You come before us, you are not before us.
Earlier, my lord, I was hopeful
You are
that
not
at least,
before us.
yes.
You can respond to
Yes.
respect to the PI.
But there are, Lord, your Lordship has directed for personal appearance of the parties, Lord. They are appearing today, Lord. Last order.
Last order.
Yes, 22-1, Lord. Para 16 last.
Para
Para 16, Lord, where, Lord,
22/1.
22-1. I'm sorry, Lord.
Yes. Para 13.
Para
Yes,
13.
what do you have to say?
Hmm.
Yes, what do you have to say?
Yes, sir. The scheduled completion was in 27 December 24, sir. And
Come to the court properly dressed, Mr. Officer, not in a jacket like this.
I'm so sorry, sir.
This is not we are not going to hear you. You come prepared. After 10 minutes. Mr. Dubey, please advise your clients. This is not how personal appearance is done.
I'm sorry, Lord.
Ask him to come after 5 minutes.
Item number 3.
Yes.
My lord, I talked to Taposa Malot. He informed me that he could not contact as they are beyond the network reach, my lord. So I pray, my lord, I may be allowed to take fresh step, my lord.
Upon the sole respondent.
Yes, my lord. It seems that we could not ascertain, my lord.
But who was appearing in the writ petition?
Writ petition, Mr. Tapo was there, my
Is
lord.
he there?
Yes, he's there. And I asked him, requested him, and he
He's
tried
in
his
touch
best.
with the clients.
Yes, he just informed me, my lord. These people are from, my lord, this sole respondents from beyond the network reach, my lord. That's why.
Okay, in view of the office notes pertaining to non-receipt of service, pertaining to the service report upon the sole respondent, comma, Sri Tagum, the learned standing council education, prays for and is granted liberty to take fresh steps in accordance, fresh steps by speed post PTD. Let such steps be taken within a period of 2 days from today.
Month.
List after 6 weeks, along with fresh service report.
Deeply obliged.
Item number 4.
Yes, what is this item 4? Mr. Parme,
My lord, I have filed, my lord, this interlocutory application, my lord,
I have for
for recalling of the order, my lord.
recalling which order?
Order dated, my lord, 3/9/2025, my lord, passed by this royal court, my lord. What happened in this case, my lord will kindly turn to page number 15, my lord.
3/9/20. Let us see the order. Even the policy order is from. Where is the order?
No order, my lord. My lord will find it, page number 22, my lord.
22, yes.
May I read this, my lord?
Yes, what is the difficulty to accommodate the petitioner in the vacant post of work
No,
as Khalasi?
My lord, this, as part of order of this, I take instruction from the executive engineer, my lord. He give me written instruction, he can be accommodated, my lord. Later on, my lord, this SE, my lord, saying this was yet to be declared vacant by the competent authority, my lord. The process is, my lord, whenever vacant is post, my lord, that need to inform to the routed SE to the CE, my lord. Now CE will declare vacancy of the post, my lord. Now there, my lord, it need to be determined whether it is promotional or direct post, my lord. Now in absence of declaration being this is direct post or promotional post, my lord, this early accommodation, my lord, would not be possible, my lord. So that may affect the third party right, right, my lord. That's why, my lord.
You make it subject to further orders that may be passed in the grid court by the court. This order of 3/9/2025
My lord.
was passed on an instructions given by you.
Yeah, but true, my lord.
Can you resile by the instructions, written instructions? It was not even an oral instruction. And what was the order? Kindly see what is the observation of this court. Instructions were sought for in view of the office from Madam so-and-so, whereby the private respondent being transferred from the establishment of so-and-so to so-and-so against an existing vacancy. A work charge Khalasi post has fallen vacant under the executive engineer SLDC in view of the instructions placed before this court. Respondent is directed to take steps to accommodate the petition the vacant post.
My lord.
This is an interim arrangement. We can clarify that this will not vest any right upon him. And such arrangement would be subject to final outcome of the writ petition.
My lord, my humble sir, better, my lord, instead of that, my lord, my humble sir, after victim, my case be different on merit, my lord. Otherwise, my lord, this instruction, my lord, I do consider, my lord, was given to me E, my lord, written instruction, my lord. But the SE is saying, my lord, this was never
But
brought.
if, then you file a proper review. It cannot be an IA. You need to invoke a review jurisdiction. It cannot be in the nature of an IA. You are trying to change the entire order. Your prayer is for changing the entire direction.
No, my lord.
This will require a review. And if it falls within the contours of review, our scope is limited. You file a proper application, not in nature of IA. Let them file the review. You cannot get something done by filing an IA when law prescribes that there has to be a review.
My lord, my humble submission, my lord, this by this order, my lord, this case, my lord, was not finally disposed of, my lord. My humble submission, my lord, ultimately, IA, my lord.
You have to file a review, Mr. Parme. We are not required to educate you. You have asked for reviewing the order in the guise of a review. You have filed the IA. You have to file a review.
Review, my lord, during a pending main case, my lord, ultimately review also will be in, for my humble understanding, IA, my lord, only, my lord.
How can review be an IA? It can be, nomenclature can be an IA, but review has to be filed in accordance with law. There are requirements to frame grounds. There are requirements to have a certificate. It's not that easy. That you file an application, get something deleted. You file a review, your difficulty you will face. We are not here to emulate to difficulty. Whatever the law prescribes, you have to follow the prescription of law. Okay? Well, he has to file a review. You are appearing in person.
Yes, sir.
Okay. Third, Sri L. Parme, learned counsel for the applicant. Courts have also heard the petition, also heard the opposite party writ petitioner who has appeared in person, put up by this interlocutory application, comma, the prayer is for review and recall of certain observations made by this court in its order dated 3/9/2025, passed in WA 5 of 2023. Full stop. We are, however, of the opinion that the prayer made is a prayer which is of reviewing the earlier order. Full stop. When the rules holding the field prescribes for filing a review application, comma, the same cannot be replaced by filing an interlocutory application. Full stop. Para. The interlocutory application is accordingly dismissed with liberty to the applicant to approach this court in the proper form and in the proper manner.
Item number 5.
Item 5, my lord, this is an IA.
9.
5 to 9, they are connected.
Yes,
Those are
yes.
connected.
5 is an IA
IA
for condonation of delay in 41 days in connection with item 8, read appeal 49. Mr. Parme was there in
Mr. Parme for the petitioner.
Yeah, my lord.
Will condone the delay.
My lord.
Okay. This is an item number. IA in connection with.
item number 8,
Okay.
read appeal 49.
Okay. The instant IA has been filed under section 5 of the Limitation Act 1963 for condoning delay of 41 days in preferring the appeal against the order dated 17/9/2025, passed in WBC number so and so. Full stop. Heard 3 N. Ratan learned AAG for the applicant and 3 L. Parme learned counsel for the
Respondent
number 1, writ petitioner. Full stop. 3 Kato is present. The Kato deputy GI is also present for the for the Union of India and other respondents. Yeah, Airport Authority, you are there? Are there for Airport Authority of India? What's the para? Sri Ratan Dilane AG, by drawing the attention of this court to the averments made in paragraphs 4, not 4, paragraph 4 and 5 has submitted that due to compelling reasons which were not which were beyond the control of the applicant, the delay has occasioned. Full stop. The learned counsel for the respondents have not seriously objected to the prayer for condonation of delay and has submitted, full stop. Sri Parme has submitted that he would contest the appeal on merits. Para. In view of the above, no, don't write. The law, the law on the subject of condonation of delay is settled by our catena of decisions of the Honorable Supreme Court, wherein it has been laid down that a pragmatic and justice-oriented approach should be taken. Full stop. We have noted the grounds of delay and also the fact that the delay is not an inordinate one. Full stop. Para. Considering the above, the delay of 41 days in preferring the appeal is condoned. The IS stands allowed. Full stop. Let the appeal be registered and listed for admission.
Second melon, may I press pick the melon? Second.
Okay,
March.
when as prayed for, list on
2 melon, 2 March melon.
2nd March.
Melon.
Let us have it on 3rd of March. It's a DB day, Tuesday. 3rd or 5th. 3rd, Mr. Dubey. 3rd. Okay.
Also for matter item number 2.
Yes, come. Yeah, our purpose was nothing else. It is a court proceeding. We need to maintain certain decorum.
Yeah, I understand.
That is the purpose. There's nothing to. It's only in accordance with law. That is just what do you have to say?
I'm so sorry for that, sir. I'm not.
What do you have to say?
Yeah,
On the
yes, sir.
merits?
Yeah, sir, my name is Abhishek Kumar. I am the authorized signatory of this project and also the subcontractor doing the flyover part of the work. Last January, January 2025, I was inducted in this project. Previously, I had completed the package C work, so department and everybody asked me to join this project and complete this flyover. Then I came that time. And they asked me, how do you plan to complete it? What duration you'll take to complete this way? So I assumed that it should be completed. It should be taking around 1.5 years. So I said around 31st July, I should complete this project. So this EOT or extension of time was not deducted, deduced or given to me. I just, on myself, I presumed that by 31st July, I will complete it. Considering everything to be normal. Then suddenly what happened, the havoc rainy season came and everything was stopped. I was inducted into the highway work also. I was all along maintaining the work and everything was, for 4-5 months, hardly anything substantial was done for the structure, flyover part, and the highway thing was done. Somehow I came out of it. And coming to the extension of time part, sir, by October 2025, the last remaining portion of land was given to us. So as per the contract, when the land is given, 90% minimum land is given, then that should be considered as the appointed date. So I still beg for at least 31st July, I beg for at least December to complete the flyover part. And by the road part, the highway part, it will be completed well before July 31st. Sir. I was inducted very late. I have invested so many things.
Kumar, there are 2 issues.
Yes, sir.
Rain in this region is not new. We can understand that when you had made a tentative schedule, it was not done on a scientific calculation. It was a mere assumption.
Yes,
There may be here and there plus and minus.
yes,
But you cannot make an assumption being oblivious of the present, of the realities. Rain is something which is very common, and this is the season. In fact, the season is about to be over.
Yes.
For
yes.
the work to be done to the maximum capacity.
Hmm.
And this is not only for this region, this is an universal, wherever there is rain, you cannot, work cannot progress during the rainy season.
Yes.
So you take advantage of this situation, of this season, which you could not take. What was done during this dry season? Nothing.
Actually, sir, I was stuck with the financial problem previously. Around 7.5, I mentioned in the last few.
And what
hearings.
is the number of equipment? We don't see enough equipment.
Sir, we have a yard, 2 yards along, I mean, adjacent to the one near Doimuk, one near Mani Basti, and we have sufficient equipments. Whatever we say in affidavit is,
Besides, we don't see any equipments.
sir, site, you only find excavators to dig the pits. Every major machinery is in our yard. Whatever we give in our affidavit is there at the site in our possession.
If you are equipped with all the equipments, machineries, why is the delay then?
Sir, we have some financial problem. I would humbly request you give us the EOT for the end of.
We are not the owner of the work.
Yeah.
Our concern is early completion, maintaining the best standards.
Yes.
The work will be done by the department.
Yes.
They are the owner.
Yes.
You have to collaborate with the department, come up with the best results. But public is watching.
Gee. So,
Once the matter is before us, public is also watching us. What is the court doing? For the general public, court, they think that court is monitoring the matter will progress, but it's not. We don't see the desired results at all.
correct. As you rightly said, in rainy season, the construction work is, greatly affected, and particularly the foundation work. Last rainy season also.
Now we do not have any foundation work.
We have, sir, around 55 foundations left, and we plan to do that within this rainy season, before the rainy season.
Difficult.
No, but difficult, but not impossible,
We
sir.
say that whatever you are saying, you do not have an intention. You might have an intention, but it is not practicable. We have seen 6 years.
So if I have a proper cash flow, sir, it will be done, and it should be
We
done.
talk to the department. We have given liberty to the department not to terminate, but to take steps which might also require a termination. It's up to the department wisdom and discretion how they go ahead with it. We want the work to be done within time and work to be done within the best standards and quality. That is our concern, which is directly connected to public interest.
So me as a subcontractor for the flyover, I feel, I got stuck here. The people who wasted time were before me.
See, Mr. Kumar, there are situations which are much, much worse than this.
Yes.
The working condition is much worse, both from the environmental side, the hostile side. But here, this is something, and since you are experienced in this field, you said that you worked in the other phase.
Yeah.
So for you, these are all, you could have expected, anticipated, taken steps. You have collaborated with the department, but department would be under their own discretion. Mr. Ratan?
Yes.
Use your discretion.
Yes.
And get the things done. Okay. Personal affairs to dispense for it, man. Please, so what is the name of the other officer? Please give.
Mr. Khare.
No.
Tajang.
Raza, please give. Yes, Mr. Ratan.
Executive engineer, Bhagir Tajang.
Executive engineer and Sri Abhishek Kumar. You are the power of attorney.
The authorized signatory.
Authorized signatory of the contractor are present in person in terms of the earlier order. Further personal appearance is dispensed with, which would be reconsidered on the next date.
Mr. Khare is also there, brother.
Was this required?
No, that his name also should be.
Why only one person has said?
Two, Mr. Abhishek Kumar and Mr. Khare.
2 persons were required to be
Yes.
there. Where is he? Come forward.
For designation and
You have not been invited to sit. You have a responsibility. What do you say?
No, sir, I am not responsible for execution or work at all. I am-
Madam,
I
he
am
is
on-
the principal
Sir.
contractor, madam.
Sir, I on
You're responsible.
May I clarify?
Principal, what are you saying? Should you record it? Mr. Department, Mr. Ratan,
No,
He's
no,
not responsible.
No, my lord, may I clarify?
No, Mr. Dubey, that is his understanding. He's a seasoned person. That is his mindset. The principal contractor is not responsible.
No, sir, I am not saying principal contractor is not responsible.
Then-
Let me clear that. Myself, I am talking about myself as a person, sir.
Then whom are you representing?
Sir, my work is not about execution of work. I am at headquarters, do rather advisory work. That is why I am not needed to be present here, sir.
Then who is the principal? Who is the person responsible?
That's why I was clarifying.
Yes,
that
who
what
is the
has
per-
happened. Your lordship has earlier passed in direction that the director should come, my lord.
Yes.
But he met an accident with the aircraft that we have indicated. Therefore, in lieu of him, my lord, Mr. Khare had come, my lord.
And he'll come and make a statement.
No, my lord, that is
If
not.
you are authorized by
No,
the
no.
director to appear in the court and make a statement, Mr. Khare, you are inviting yourself to great trouble.
Sir,
If you come as a representative capacity of the director and you say that you are not responsible,
I came on 24th, sir, on that.
we do not know you are being represented, you are being authorized
On-
by the director.
Sir, sir, I'm sorry, sir. I'm sorry.
This is not you protect yourself.
Sir, what I want to say, sir, what I wanted to say that on 24th.
You are not responsible,
Oh.
Mr. Abhishek Kumar is not responsible. Who is being responsible?
No, Mr. Asukos is authorized signatory, sir. He is responsible. On 24th December, sir, I came with authorization. Furthermore, sir, I am not.
Now gradually we are also feeling that you do not have any intention with to go ahead with the work.
The company has intention, sir. I want personal capacity, sir. I want to leave, sir.
You have forced us to raise serious doubts on your intention.
The principal contractor, my lord, since the inception, my lord, has not been actually executing the work. It was sublet to another firm. That was cancelled. He was brought in. That is how they're working.
Subcontractor is allowed, I think. Allowed
Up
by
to
the-
49% actually. Now they have done this in such a manner that he is a subcontractor also. That is how that 49% is, my lord, been maintained. He's also the representative of the principal, but he's a different firm. His firm is totally different. That is how they have managed that 49%.
Yes, department's role also becomes very
My lord, the
dubious.
department cannot, they
Department
cannot
role
just
also becomes
go ahead and say that we have done nothing. They are also
Role has
totally
become,
responsible
very
actually.
doubtful.
Department is
How you
totally
are going ahead
responsible.
with the execution of the work.
Department did nothing.
We might have to explore the option of having a CBI inquiry.
My lord, yes, my lord.
On this,
That's the requirement, my
who is
lord.
responsible?
Yes.
How the work was done? How has it been executed? How was it allotted?
Yes.
And who is responsible for and to take appropriate action in accordance with law?
Yes.
That you are inviting the court to do.
Department is
We
actually.
will seriously explore this option.
Yes, my lord.
Next date, question. Huh?
27th, your lordship has fixed the date.
We'll seriously explore this option.
Yes, my lord. If there is
Many things
anything wrong,
are appearing now, and many things will appear. Let us see.
But can I make one prayer, my lord? But I have just find out 27th, I have some difficulty. Could it be on 25th or 3rd? My lord, 3rd, your lordship.
We have given the date. We'll not accommodate Mr. Dubey.
My lord.
Number 10.
I think it's CBI inquiry.
My please, Lordship. My lord,
Yes, Mr. Tuff.
this is criminal appeal, my lord.
Item number,
10, my lord.
it's for hearing.
Yes, my lord. Lordship,
Yes, Mr. Lodji, you're there. You're MP.
Yes.
And you're the amicus
Yes.
for the victim. Response number 2.
complaint, yes.
Complainant.
Paper book is there.
Yes, my lord.
Can you go ahead with the hearing today?
Yes, I'm ready.
This is directed against the, my lord, judgment and order dated 27/7/2023, my lord. This is jail appeal, my lord. My lord, the FIR is page number 1 of the paper book, my lord. You should not have this down to 2%. When I took we should have direct to if you're there, then this section will have a positive impact. So we will have
Yes.
Page number 1 of the paper book is the FIR.
Don't they see? FIR is at page 1.
Yes,
Yes, please.
here, I have the honor, I'm reading, honor to inform you that on 22nd 1/2023 at around 2100 hours, my husband Ranbir Singh Kumar, ex-army, has killed my 2-year-old son by holding both legs and hit his head on the floor. He has physically assaulted me hand and got severe injury on left elbow. Meanwhile, my brother Deepak Vishwakarma, who was sleeping next room, entered our room and intervened. After killing my son, assaulting me, he ran away from the house and did not return back till now. My son was brought to District Hospital Town for immediate medical treatment. He is surveyed, but the doctor declared him brought death. Therefore, I request you to kindly take stringent action against my husband mentioned above for killing of my 2-year son and physically assaulting me.
Just a minute, please.
Yes. It's in.
Yes, please.
Now, the prosecution has examined as many as 8 witnesses to support his argument. In this case, what happened? There was a quarrel between husband and wife. They were only and that was in their bedroom. And no independent witnesses there in this matter. Only both of them know what happened between them. Now, Lordship, the first prosecution witness, the complainant is page 45 of the paper book.
How many PW?
8, my lord.
8 PW.
Yes.
Yes, Learned Counsel, why don't you sit? Why do you stand on the back? There are chairs. Sit. Yes. PW1, who is PW1?
PW1 is the complainant and my lord, also victim. And this is the child.
Mm.
My lord, the accused standing on the dock is my husband. On 22nd 1/2000, with my husband and my son, Aman, aged about 2 years, went to Gompa and had our lunch. We reached back home, which is situated Manjushri, Tawang, at about 6 p.m. I have prepared tea and we consumed the tea. There was tea left on the pot. Hence, I asked my husband for heating the same to have. The gas was on its full flame. I asked him to decrease it, but he closed the same and went to sleep. Thereafter, I have prepared dinner and asked my husband to have dinner with us, but he told that he will not take dinner. One of my brothers, namely Deepak Chatri, used to stay at nearby room. I asked him to have dinner with us. Accordingly, I, along with Deepak and my son Aman, had dinner together. After dinner, Deepak went to his room to sleep. At about 8:30 to 9 p.m., I went to bed to sleep, but I have seen that my husband was sleeping on the bed and he wrapped the entire blanket around his body. I asked him to share the blanket so that I can sleep with him. During that, my husband shouted on me in a loud voice, for which my son was afraid of, and he was crying. He was telling Mamaji and Papaji. My husband got up from the bed and he was going to another room to sleep. I told him that if he does not want to sleep with me, he may go to another room to sleep. During that, he was taking away my son Aman. I told him that he may not take the son with him. During that, he shouted on me and told that if I do not allow my son to go with him, he will kill my son. Therefore, he snatched my son and hit my son on the floor by holding his legs. I tried to restrain him from doing such act, but he has pushed me and broken my left hand on elbow, and thereafter again hit my son on the floor. There's Hindi translation there. My son has sustained injury on his head, and blood was oozing out from his mouth and nose. He was not making any sound. I shouted for help. Hearing my sound, Deepak came to our room and knocked the door. I opened the door and I was shouting for help as my son was not moving. I, along with Deepak, immediately took my son to hospital, but doctor has told me that my son is no more and died due to injury sustained on him on his head. My husband has fled away from our residence, and he even did not took me or my son to the hospital, though my left hand was broken and my son sustained injury on his head and he was bleeding from nose and mouth. The witness, yes, at hospital, I found the head, leg, and head of my son was broken. I was medically examined, treated due to dislocation of my left elbow. I was admitted in the hospital for 1 day. I have lodged the FIR. I have taken 2 X-ray frame of my left hand, which was taken at Tawang Hospital. I'm producing the same today before the court for perusal. And those were exhibited. My lord, in cross-examination, nothing has come out admittedly. The defense could not, my lord, anything that could contradict the matter. This is the prosecution story, my lord.
Okay.
Now, my lord, in this matter, the occurrence of incident, my lord, shouting and everything, that's not contradicted by the other witnesses, my lord. She shouted, and the next PW2, my lord, he came and she also saw aftermath of that incident, my lord. The incident, the actual incident, nobody saw. It was between the husband and wife. Now, of course, my lord, if you, Now, the important point is the medical the doctor's opinion,
PWT is the brother of the
alleged brother, yes.
Deepak.
Yes. He was the person who was nearest, man.
Hmm.
His cousin sister, according to in a cross-examination, that's what he says. Not real sister, but cousin sister. The medical report is definitely the injuries is the PW7 is the doctor.
Let us go one by one. Who is PW3?
Yeah. PW3 is he's the brother, man. He was called, man. He went to the Tawang to see the body and sign on the inquest report. He has not seen the incident. That's in a cross-examination. PW4 is the neighbor, one of the neighbors. He heard the noise and came out from his room. And he saw this Deepak cousin brother holding the child to take to hospital. And he's seen that child was bleeding from his mouth and nose. And he took them to the hospital. And he was already declared dead by the doctor. And cross-examination, he says he didn't see the incident. PW5 is the doctor who conducted a postmortem. The medical report shows injuries on the skull, mostly. The second paragraph. Depression seen on the left side of skull, frontal and parietal bone of skull was giving crackling sound on touch. There were diffuse bruising on scalp in blue color. There was a huge amount of blood and blood clot. Blood is around 20 ml and clot is about 10 grams on left side of skull. There was 15 grams of brain matter present below the scalp. On further dissection, depression, multiple fracture of skull involving frontal, parietal, temporal, and also right parietal bone. Further dissection, corneal meninges which protect the brain is found ruptured and sustained with blood. On further dissection, avulsion of middle portion of left hemisphere of brain was found out. Left lower limb was also found below the level of 1/3 of the thigh. There was puncture wound and below the injury, the leg was freely moving and externally rotated. On further dissection, it was found that there was displaced compound fracture of lower 1/3 of the left shaft femur bone, thigh bone, longest and strongest bone of the body. On completion of PME, we are of the opinion that the cause of death is due to avulsion of middle portion of left hemispheres of brain following head injury. Nature of injury is antemortem and time of death of PME is 6 to 24 hours. It was found that there was severe head injury on left side of the head with blunt trauma causing death of child. Left side, the injury was caused. Yes. In a cross-examination, also, there's nothing to contradict the injury. Now, the only thing is, the opinions of doctor in cross-examination is that such injury, which was found on the head of the child, I'm reading fourth line,
The cross part.
Yes, fourth line. Such injury which was found on the head of the child may be caused by falling from a good height. This type of injury is seen in road traffic accident where there was depressed comminuted fracture. I do not know who have clicked the photograph of that. It can be caused of falling from a height and also in a case of road accident. And PW6 is the doctor who saw the complainant mother. Oh no, sorry, this is the person who has who in his house the accused person was staying after the incident. And accordingly, he handed over the accused person to the police. The incident happened at Tawang. This accused person was at his house at Jang after the incident.
Yes.
He PW7 he is the emergency medical officer who examined the complainant. In the last paragraph, he says the injury of the complainant is dislocation of posterior aspect of left elbow. The left elbow of the complainant was dislocated. This is the injury report. In cross-examination also, he says he could not initially find out, but after X-ray internal injury, and the injury can happen if a person falls and hits her elbow. That's his opinion. And PW8 is the IO of the case. PW8 basically states the manner in which he has conducted the investigation and charge sheeted the accused person under 302 and 325 IPC. For grievous injury and for murder. My lord, in the cross-examination, the IO of the case admits that there was quarrel between the husband and the wife, the accused and the complainant, and they didn't have a peaceful life, my lord, as a husband and a wife.
Where is it?
It's my lord, in cross-examination, my lord, page 61, my lord. Sixth line, my lord. It is a fact. Sixth line, my lord, is here it's written. It is a fact that there was quarrel between informant and accused before the incident.
Yes.
It is a fact that there were no peaceful involvement in the marital life between the informant and accused. It is a fact that I have recorded statement of cousins and relatives of the informant, and there are no independent witnesses. And my lord, it is a fact that there were pull and push between the accused and informant regarding the child.
Yes.
These are the two or three vital, my lord, the investigation officer has said. Now, my lord, from the defense side, the accused himself was first the defense witness. Now, lordship, because the incident, that's why I'm harping on the thing that there was no any independent eyewitness to the incident as such. It was between husband and wife. And this is the version of the accused husband. Page 62.
Yes.
The first portion of the incident where they says it corroborates everything that they went to the Gonpa, everything they had peaceful, went to monastery and all that. I'm reading. On this 22nd, 2023, there was Torge is a festival, at Tawang Monastery. I asked Deepak as to whether he wished to go to monastery with me. He told me he asked me to proceed and told that he go to monastery at 2 p.m. I, along with my wife and son, went to monastery, but we were late to return home. But by the meantime, Deepak went away, closing our shop. Though we had asked him to look after our shop, it was about 5:30. My wife started to scold, though he was not at home. I opened the shop and there was some materials in the vehicle which I must arrange it. And during that time, my wife was preparing tea for us. Thereafter, we drank the tea together. During the time, my wife also scolding Deepak. At about 6:30, Deepak came with some beer and started to consume the same, but my wife has not told him anything. At about 7 p.m., I closed my shop and went to warm the tea while my wife was preparing dinner. Though the flame was low, but my wife asked me to decrease the flame and told that there was no one to clean it. When I switched off the gas and turned back, she thrown away the teapot. I have not said anything. I went to change my dress and thereafter slept. Thereafter, both my wife and Deepak had dinner. I was asked by Deepak to have dinner with them, but I'm not denying. But I denied, telling him that I was not feeling hungry. At about 8:30, wife and my son came to sleep on the bed where I was sleeping. My son was watching mobile, sleeping with me. We were taking the blanket, but my wife was shouting on me regarding the blanket. I replied her that if she is angry with anyone, she can tell that person and she may not shout upon me. During that time, my son started to cry. During that time, my wife told that is her residence and she will do whatever she likes. And if I am not willing to obey her, I may leave her residence. I told that I will go to shop or car and sleep for the night. During that time, my son came behind me and I have taken him on my lap. During that time, my wife started pulling my son holding his leg. I asked her not to do so or else his leg may be injured. When I was about to leave with my son, my wife shouted that she will not leave both of us and pull my son holding his leg, for which my son fell down on the ground. When my son was crying, I have again lifted him up and was supposed to take him to the hospital. During that time, my wife pushed us from behind, for which I, along with my son, fell down on the ground. Thereafter, my wife went out of the room and started to shout to gather the villagers. During that time, Deepak, who was outside of the room, came inside the room, and due to shouting of my villagers started to gather. Earlier also I was threatened, for which I was afraid. I took my son and kept him on the bed. And when I went away from the residence, as the villagers were there, I did not know what had happened thereafter. On 31/12/2022, at about 9 p.m., I went to the residence of Vicky Vishwakarma to drop some materials. During the time, I received a phone from my wife, who scolded me and told that I may sleep wherever I am, and that I told Vicky to talk with my wife. Vicky is the brother of the complainant. Vicky told my wife that I was at his shop only. When I came back home, household materials are scattered and wife has not prepared any dinner. I asked for dinner, but my wife asked me to prepare myself. I prepared Maggie for both of us, but my wife has not eaten the same. Wife slept with my son. When I slept on the bed, wife went to kitchen and came back with a knife and placed the same on my neck. I snatched the knife and thrown it away. She threatened to kill with my son. I could not sleep on that night, but Mrs. was sleeping. Earlier, Vicky assaulted me, for which there was information to Women Commission, and there's a agreement that I will live separately from my wife, and I was to pay maintenance for my child. I went to take my materials, but I was not allowed to take my materials, and was told that I have to stay there to stay with me 2 days in a week. After a few days, my wife had quarreled with me and she drove me out of residence. On that night, I was sitting outside the residence. Next day morning, sister-in-law came and consoled me to stay with my wife, promising that things will not be repeated again. Those things repeated again and again with me, but I stayed with my wife for my love to the son. I have no wrong in death of my son, and he has died for the fault of my wife. There was no any cross-examination to contradict the statement of the DW1. Lordship is in PP absent to cross-examine at defense business, hence the cross-examination is closed. And DW2 is the brother of the accused person. Here, only, I'll just read. I have received a phone call from Tawang PS, who has informed me regarding present case. After about 2-3 days, I came to Tawang and met Ashok, who is my younger brother, and asked about the incident. I was told that during the time of incident, he was sleeping and his son came, he's behind me. There was quarrel between Ashok and his wife, Mamta Chetri, and during the time, child fell down. During that time, Mamta Chetri started shouting, public gathered there, and due to fear, Ashok went away. I am told Ashok does not know what happened there, as he was not there. When I came to meet Ashok, I have received a phone call from office bearer from Women Association, who asked me to come to Tawang for discussion. Thereafter, on 7th May, I met the lady with Mamta Chetri, this complainant. When there was talk of compromise and Mamta demanded rupees 10 lakhs from me, as I was not having money to pay her, I denied it to compromise. When I was about to go, I have talked with Mamta Chetri, who asked me to deposit money in her account. Thereafter, I went back to Chandigarh. I did not know much about the case except the deposition. Since December, I've been calling Ashok, as my father was suffering from some ailment. My father also called him. I asked Mamta to send Ashok, but she denied and told Ashok was not there. Of course, in the cross-examination, the prosecution asked him whether he knew about the incident or not. But he, of course, he was not there. He wouldn't know about the incident. He was only hears the evidence. He learned it from his brother, accused person.
Yes.
Now, this is the thing. In 313, of course, there's nothing, because the Lordship will see page 67. Most of the answers, it is a fact, it is not a fact. Those are the answers from the accused person. I don't know why those things were not elaborated or encouraged to elaborate the matter to Malad, discuss about the fact. There's nothing more except that in the 313, he says it's a fact, it is not fact. That's the answer to all the question, most of the question. And one cases, the only thing is that about the Deepak Karma, man. He says it's not a brother, man. That's the only thing he has stated. Now, Lordship will...
What are your grounds of challenge?
Now, Lordship will kindly appreciate, my lord. Here, only two witnesses are there, my lord. Independent, if we say, my lord, prosecution from this, the complainant is the witness. And from the defense, the husband is, the accused person is the witness. The version of the complainant is different. And the version of the accused person is different. The version of accused person says that it was the wife who pulled the leg of the child. And definitely there was a fight between the husband and wife. That is not denied. And the IAO has also confirmed regarding that. And the accused says both of them were pushed and they fell down, both of them fell down. That's how the injury was caused to the child.
Where is the injury caused to the accused? You fell down with the child.
Yes.
That is your version.
Yes, ma'am.
Let us for a moment assume that this version is a correct version.
Yes, ma'am.
Where is the injury you had sustained?
Malad, as per Malad,
Number two, why did you flee away?
Malad, that's the fear because he has narrated in his deposition that
You tried the child was with you.
yes,
You were there pulling and pushing. You
Yes.
fell along with the child.
yes,
Child suffered a grievous injury,
yes,
a fatal kind of an injury.
yes,
Let us assume that that injury was not caused by you.
yes.
The first thing as a father which you will do to save the child, bring him to the hospital. Where are you?
Malad, what he says in his deposition is that the wife started shouting and calling the villages.
For that will run away.
That such incident happened earlier also. That's what he stated in.
Your child is dying in front of you for some injury which has not been caused by you. Whether somebody shouts or does anything or kills even, your first intention will be to save the child. At least make an endeavor to save him.
The first,
This is the basic normal human conduct of a father. If you see your 2-year-old child
yes,
on an injured condition happening in front of you for which you are not responsible, will you flee from the place?
Malad, that's what he said. The person is.
Or you are hiding in the kitchen of one of the gram, this chairperson of the
Yes.
gram chairperson.
Yeah. That's not denied.
Normal human conduct. And why should you disbelieve the sterling witness, PW1, the informant? You have to have some credible materials to demolish PW1.
Yeah, of course, Malad. In
PW1, the cross-examination was not.
yes,
PW1 version is acceptable. PW1's version is matching with the medical report.
Malad,
Injury on the left side of the head. The version given by the description given by PW1 matches with the medical report. Even otherwise, eyewitness, mother,
yes.
and eyewitness suffering injury, her credibility will be somewhere above the normal standards. Injured witness.
Malad, the scuffle was there. Malad, there is no reason to disbelieve the Malad, DW also, Malad, because
No, see, you are a defense witness.
yes, Malad,
First, you have to demolish the prosecution witness.
yes,
How do you demolish? You are not obliged to give defense witness.
yes,
See, even without there being absence of defense witness, it's up to the burden is entire burden is up to the prosecution
admit, Malad,
to prove the case.
yes. Malad, can you appreciate the fact the person is from Chandigarh?
Whether you give defense witness, whether you say no, in 313 you have said no, doesn't
Yes.
mean that you have proved that you have not done it.
No, the version also cannot be disbelieved. Malad, that's what.
What is the purpose of 313?
Yes, Malad.
Suppose in a 313 statement you said no, I have not done it. Will it bring an end of the matter?
No.
You might very well say that
Yes.
as a witness I was there, I have said I have not done it. So there has to be one version which is the truth. And the court's endeavor is to bring out the truth. That is the entire mechanism of the justice dispensation.
Yes.
How do you bring out the truth?
Malad, of course, that is there. I admit to that Sterling.
So the mother does not appear to be, she appears to be credible witness.
Otherwise, Malad, if we see the statement of the IO also, he admits that there was quarrel between the husband and wife during the incident, Malad.
No, for quarrel, what argument can you make? Yes, let us assume that there was a quarrel.
Yes. Malad, this explanation is plausible explanation when, but they definitely that's the version of the wife and also that.
Now, what is the nature of the injury? Not just a fall. He died almost instantly. He did not even reach the hospital. 2 years. It's not a feeble 1 month old or 2 month old baby. 2 years.
2 years, Malad, as per the medical, Malad.
If it's a 1 month or 2 months, one fall gone. Here, one fall will have injury unless he's hit on the wall, on the floor.
2 years, Malad, had skulls generally wouldn't be so mature as to bear such a.
No. You're mistaken. It's soft.
Soft.
Injury is not heavy. We have seen many times a baby falls on the floor, nothing happens because it's all soft. What you're on a different plank.
Yes.
One fall of a 2-year-old may not be fatal normally unless it is hit on the floor. And he died almost instantly.
The pulling, that is not denied, my lord. The snatching of the baby by five.
Pushing, snatching was not the cause of death.
No.
That's was hitting the baby on the floor by holding his legs. That is the allegation.
Yes, man.
And those allegations appears to have been proved in accordance with.
My lord, why would a father kill his own child? Because
that is what. Why did you flee? The question will have another counter question. Father's endeavor would be to save the child.
That also,
all cost.
That also a person who has left his own hometown and for Chandigarh and is living with the wife's house, my lord, for so many years.
We have to look into the proximate materials. You have left home, you have another family. Those may not be the proximate materials.
Because, my lord, that's the clear. He states, my lord, it's a love for his son that he was staying there.
And what are your grounds? Grounds based on law.
What
is your defense?
First of all, there was no any intention that happened when the fight broke out.
No intention means what ground? Which provision?
Then definitely 304 would attract ultimately. Because
hitting a baby, 2-year-old baby on the floor, and you are saying not having the intention. What about the knowledge? If you are trying to bring in the culpable homicide not amounted to murder,
yes, mother.
You'll have to overcome the difference between 299 and 300.
300, mother, yes.
But 300, what are the?
Yes, ma'am.
At least
299 and 300.
The intention is one part.
Yes, ma'am.
The Supreme Court has said in very lucid and very settled part. Not only the intention, the degree.
Yes, ma'am.
By which the intensity and the degree by which the injury was caused. It's a probability cause death.
The plausible explanation that the child fell, both of them fell, and child was beneath the father. That can happen to 2-year child.
But why?
It's not improper.
Why did you flee?
This we have explained. She was shouting, and the villagers would earlier also happen in
that is very difficult to accept. A father, whoever shouts or kills even, he will give his life to take the child to the hospital.
That's the only plausible explanation which has been given.
See, normal human conduct. A father sees his 2-year-old son to be injured. At that time, just assume there's a group of persons who have come to attack him or the child. Will he flee or will he protect the child? even in those adverse
Yes,
circumstances.
my lord.
More than his life will think of the life of the child. See, it is not within any of the 5 exceptions, number one.
Yes.
Those are gone. But does not necessarily mean that you can still be held only for 300. You can still make out a case if it is not 300. Because Honorable Supreme Court has explained, apart from the exceptions, 5 exceptions, you can still make out a case that it may be at best 299, not 300.
Yes.
But for that, you need to see what are the facts and circumstances, appreciate. With the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death,
Yes, ma'am.
or with the knowledge that is likely by such an act to cause death, commits culpable homicide. This is culpable homicide.
Yes, ma'am.
That there is a likelihood
Yes, ma'am.
of causing the death. But 300 goes
Except in
goes
the
a bit
cases,
further.
you know. Yes, madam.
If the act of which death is caused is done with the intention of causing death, let us for the time assume that you did not have the intention.
Yes,
Let us come to the second one. If it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death of the person to whom the harm is caused. Thirdly, if it is done with the intention of causing bodily injury to any other person and the body is intended to inflict is sufficient in the ordinary course of nature to cause death. It is the degree of the intensity of the injury.
Yes.
Culpable is likely to cause death, but here it's sufficient in the ordinary course of nature to cause death. Thirdly, we'll cover your case. Fourthly, may not that you don't
Yes,
have an excuse.
That is a plausible explanation, my lord, I can give you in this case, my lord. I have
Any more grounds, legal grounds
my lord,
you can please urge.
my lord, that's the main ground we are urging, my lord, in this case. Further that, my lord,
Any infirmity in the investigation, any infirmity in
no, my lord, we have explored all the possibilities, my lord. Unfortunately, we definitely infirmity, my lord, with trial and all that. For retrial, we are not urging. Here, madam, only what the second ground is that of course, madam, the burden would definitely not shift to the defense as such. It's the prosecution which has to prove, madam. But what I'm submitting is the defense evidence also is plausible, madam, explanation to the cause of the death. Because there was no any cross-examination to dispute that.
We have to balance.
Yes.
First, the burden is entirely on the prosecution.
Yes.
Whether they are able to overcome the burden, irrespective of the fact that you give defense witness or
Yes.
not. Now, if you give defense witness, you may add something more to your thing,
Yes.
grounds of defending yourself.
Yes.
But you have to balance it. Whether the version of the prosecution, which is corroborated by the medical evidence.
Medical evidence is bad, man. I admit to that.
Your report is there.
Yes.
You gave him a suggestion that you can also death may be done because of a fall of this nature.
Yes.
But
What we are submitting is first of all pull by from the leg. That is not denied, man.
And what about this thing? Injury on the elbow dislocation. How did it happen?
Well, that has not been explained by the accused person.
Contemporaneous. It has happened on the same night. It is not that some previous injury or subsequent injury has been. She was injured.
Definitely, there was pushing and pulling. That has not been denied, man, between the husband and wife.
Pushing and pulling will not cause. This is a dislocation.
Pushing and pulling, she might have fallen during that.
Because this is not something which has been introduced later. If you read the
FIR, yes, man.
Which was logged on the same night.
Yes, yes.
The incident we have just noted. The incident was of 22/1/2023
Yes,
at 21 hours. Okay?
yes,
And the FIR was lost on 22/1/22, same day,
yes,
on 22:30 hours. Incident happened at around 9 o'clock. At 10:30, the
Yes.
FIR was lost. And she has said that after, he also physically assaulted me, on my hand, and got severe injury on left elbow. Left elbow is consistent, dislocation. Thereafter, meanwhile, brother came, Deepak also corroborates. Deepak is PW2.
two, madam, yes.
Deepak is PW2. Deepak corroborates exact version. After killing my son and assaulting me, he ran away from the house and did not return back till now.
That much I can urge, my lord. I've gone through the record so many times, my lord. That's the only plausible defense I can put up in this appeal. In my humble submission, my lord, it's a spur of moment. There was a quarrel between the husband and wife. There was no intention to kill the Malay child as a father.
If we are trying, we anticipated this. Then you let us see what is the exception. If you can urge anything, let us see which exception.
Market. Captain, yeah. Yes, exception, my lord. So spur of the moment, my lord, that was done.
Which one? Which exception?
One second. Yes, sir. Exception. That 300 only, my lord.
No, 300. Which exception? There are 5 exceptions.
Yes, my lord.
Which one? Where is it? Let me see.
Yes, it's bringing, yes.
One more to him. Why only one book? DB?
My lord, 4, my lord, that's
4. Let us
Yes.
read 4 exception 4.
Yes.
Please read. Please read.
my lord, yes. If the person committing the act knows that it is so imminently dangerous that it must in all.
No, you're on the exception.
Yes.
You're reading the 300.
300,
If you
yes.
want to bring your case
Yes.
under the exceptions, one of the exceptions, so that it can be converted into 299,
Yes.
you have to, under which exception? There are 5 exceptions.
Yes, madam. Exceptions. 299.
Exceptions to 300.
Yes.
When our culpable homicide is not murder, exception 1, what is 1? What is 2?
Madam, what we are saying is, madam, the intention was not there, madam, in that.
No, you are saying that there was heat of the moment. You have used the expression heat of the moment. If you are using heat of the moment, you can perhaps rely on some exception. You are not even urging those. Mr. Logic,
Yes.
please help your colleague.
Yes, ma'am.
Which exception? At least let us discuss whether it's applicable or not. It's a different matter.
Google Chrome. Okay. So, is it exception? Right. Not a good. Not a good. Make out a place of then you have put the question. Is not just
Facing exception one, reason submission. Please make the submission. Different matter. Not interest. Bring that to most people. Yes, Mr. Rajiv.
Yes, my lord. My lord, this is a very clear case where prosecution has proved beyond reasonable doubt. First here, my lord, here PWD1 is herself is one of the injured victim. And here my lord, date, timing, place of incident, all corroborated. Even DW is one is corroborated the incident, place, time, and thing. And let's see if we go by the deposition of the PW1, it's very clearly and categorically stated that here accused had intention. He clearly, as per the statement of DW1, accused said that if he is not allowed to take the children with him, then he will kill the child. And since she tried to stop him, then he hold the child from both the leg and hit on the floor. And instantly appeared that the child died. And thereafter, what happened? Then here GW1 shouted for help. And immediately PWD2 was residing nearby, next door. And he came, knocked on the door, and he saw that both the accused and here PW1 and child was there. And instead of here accused here, my lord, taking the child to the hospital, he ran away from there. Incident, place of the occurrence. And then here DW2 and my lord, PW2 and PW1, with the help of PW3, they took them to the hospital. And here, my lord, hospital also medical report, everything has corroborated the description, allegation made by the PW1. Be the injury.
Who is doctor is PW?
PW5 and 5 is the one doctor who conducted the postmortem.
PM.
And PW7 is the doctor who examined the PW1. He had a complainant.
Informant.
Yes, informant, because she was also suffered dislocation in her left elbow.
Yes.
Here, my lord, the prosecution witnesses very categorically stated, all corroborated, my lord. If I take my lord to the statement, my lord.
Please read.
I'd like to take my lord to the course from PW1. I'll read from the first, my lord. Accused standing on the dock is my husband. On 22/1/2023, along with my husband and my son Aman, aged over 2 years, went to the Gompa and had our lunch. We come back, which is situated at the Manjusri Tawang at 6 p.m. I prepared tea and we consumed the same. There was a tea left on the pot. Since I asked my husband for heating of the same to have, the gas was on its full flame. I asked him to decrease it, but he closed the same and went to sleep. Thereafter, I have prepared dinner and asked my husband to have dinner with us, but he told that he will not take dinner. One of the brother, namely Deepak Chetri, used to stay at the nearby room. I asked him to have dinner with us. Accordingly, I, along with Deepak and my son, had a dinner together. After dinner, Deepak went to his room to sleep at about 8:30 to 9 p.m. I went to bed to sleep, but I have seen that my husband was sleeping on the bed and he wrapped the entire blanket around his body. I asked him to share the blanket so that I can sleep with him. During that, my husband shouted on me in the loud voice, for which my son was afraid of, and he was crying. He was telling Mamaji and Papaji, my husband got up from bed and was going to another room to sleep. I told him, till here, my lord, there is no contradiction. Even here, DW agrees till this, my lord. After that, I told him that if he doesn't want to sleep with me, he may go to another room to sleep. During that, he was taking away my son, Aman. I told him that he may not take the son with him. And during that, he shouted on me and told that if I do not allow my son to go with him, he will kill my son. So here, my lord, is very clear that he has intention knowledge. Thereafter, he snatched my son and hit my son on the floor by holding his legs. I tried to restrain him from doing such act, but he has pushed me and broken my left hand on elbow, and thereafter again hit my son on the floor. बच्चा को floor में पटक दिया. Not once, my lord, twice. He hit the child on the floor, and it's very much knowledge of the normal person, my lord. If we hit the children by holding on leg on the floor, in all probability, child will die, my lord. This knowledge was, he had this knowledge. And my son had sustained injury on his head and blood was oozing out from his mouth and nose. He was not making any sound. I shouted for help. Hearing my sound, Deepak came to our room and knocked the door. I opened the door and I was shouting for help as my son was not moving. I, along with Deepak, immediately took my son to the hospital, but the doctor has told me that my son is no more and died due to the injury sustained by him on his head. My husband has fled away from our residence, and he even did not took me or my son to the hospital, though my left hand was broken and my son sustained injury on his head, and he was bleeding from nose and mouth. At the hospital, I found that the head, leg, and head of my son was also broken. I was medically examined and treated due to the dislocation of my left elbow. I was admitted in the hospital for 1 day. I have lodged FIR. I've taken an X-ray frame of my left hand, which was taken at Tawang Hospital, and I'm producing the same today before the court for perusal. My lord, here, Lordship has earlier clearly observed, he saw that the child was severely injured. Blood was oozing out from his mouth. He was in such a condition, critical condition. Instead of taking them to the hospital, he ran away from the scene, my lord. This should be in the normal course of the thing, my lord. Father would take the child at any cost, even if he is attacked by a third, fourth person. And if he was very much apprehended of that complainant and other will beat him, he could have gone to my lord police. This has happened. But he didn't go to the police. He ran away from the scene at midnight, leaving behind injured son and wife. And he was hiding in some other place, Jang. That too in the under construction building of PW7, my lord. And from this conduct, my lord, it's very clear, my lord. Though he is saying that the child was fall down in the process of pulling and pushing. But if that were the injuries caused by the pulling and pushing, then why he would run away, my lord? He would have gone to the police. But from this conduct, my lord, it is very clear that he has committed a crime. He was trying to escape from the he escaped from the scene and tried to escape from this court of law. And here, my lord, the statement of PW1 is also corroborated by PW2, my lord. May I read, my lord? Here in my lord, in the cross, here, complainant has informant has admitted that there was quarrel. That's because, my lord, here informant is the second wife. And accused is already having another wife at his native place, Punjab. There also he has 2 children. It's a natural, my lord, in their family, that there would be quarrel, my lord. And this fact was admitted by the wife also. And may I take my lord to the PW2 deposition, my lord. Accused is standing on the dock is my brother-in-law. He is Ranbir Kumar. I stay on the
We have
right.
read the deposition.
Yes, my lord.
Mr. Tafo has
Yes.
elaborately. If you want to point out something in the deposition, you can do, but
No,
there's
my
no.
lord, otherwise, my elder brother has pointed out in post-mortem also injury is very clear. All the witnesses have corroborated the statement of the PW1 informant. And my lord, here injury, everything is corroborated by doctor, IO, and witnesses. And in the cross, they could not discredit or obtain a contradiction from them, my lord. Here, prosecution proved the case beyond reasonable doubt, my lord. And he has been rightly convicted for committing offense of
What is the sentence?
sentence is life imprisonment and 7 years for causing a grievous injury to the informant. And both have to go concurrently. So my humble prayer is that this honorable court dismiss this appeal and upheld the judgment order passed by the learned session judge.
Yes, you would like to say anything? The victim.
I'm with Laji's submissions, Planet Amicus. Only thing what I want how to say that there is
and
You're amicus, legal aid counsel.
no, I'm additional PP.
Additional people. No, but we're hearing only one. Huh? You appeared for whom?
I'm appearing for the one of informant, my lord.
Oh, you
Amicus.
should have heard him first.
I'm for state.
We are under mistaken identity.
And then my lord,
That
one,
is, but you have done his response. You have discharged his responsibility.
Yes,
Aptly.
almost same submissions as Planet Amicus has submitted.
Lazi is for whom?
I'm for the informant complainant.
Your legal counsel or
Yes, amicus.
amicus
Amicus.
for R2
R2, my lord.
and Tado is APP.
Yes.
Yes, so you have to hear you also. Yes.
My lord, before my brother make a submission, one small submission. Since my brother is saying that there was no independent witness, single witnesses. And Apex Court has taken up decision that even on sole witness, if witness is consistent, reliable, my lord, is of outstanding quality, conviction can be solely based on that, my lord. In this regard, my lord, I'd like to submit a citation of the Apex Court, my lord. 2024, 14 SCC 203. And 1990. Name, my lord, Prahlad versus State of Madhya Pradesh.
Para?
Para for 41, my lord. And another, my lord, from our 1993.
(1993)
3 SCC, page 282, para 3. Anil Pukan versus State of Assam.
Anil Pukan has been referred by the in Prahlad case.
Yes, my lord.
1993 SCC?
3 SCC, page 282.
Anil Pukan.
Yes, my lord.
Paragraph? Anil Pukan paragraph?
Paragraph 3, my lord.
3. No, supply. This is not the one, madam. You have got a supply. This is not supply. Normal. 1993 SCC, not supply 3.
That's all, my lord.
Anil Phukan Pera?
Para 3, my lord. Anil Phukan.
Yes, Mr. Tador?
Yes, Your Lordship.
You have to,
Here, intention and knowledge is very much clear to commit such a heinous offense. Lord, Your Lordship, here victim informant is a eyewitness, and rest others are hearsay and official witness. So, sole testimony can be when it is unblemished, it is trustworthy. That can be a ground for convictions. Madam. As pointed out by the learned amicus curie, I like to add that post-mortem report corroborates with the FIR, and there is a accused was caught by some common person at Jung, and his fleeing away clearly suggests that there is a intention and knowledge. By pulling the leg and hitting on the floor, definitely the tender age of 2 years and suffering of serious injuries, it depicts that he has a knowledge and intention, and for this, Your Lordship, impugn judgment may be upheld and appeal may be dismissed. That's all, Your Lordship.
what is this Ganesh? Who has placed Ganesh?
This is, Your Lordship, Para,
You're relying on Ganesh.
yes, page 5.
Uh,
1, 2, 3. Page 5.
2020, 10 SCC,
Yes.
573. Paragraph?
Paragraph, page 5, 1, 2, 3, third para. Where it? Third para on evaluating the position.
9.9.3. 9.3, it is on Sterling witness. This is Rai Sandeep.
Yes, here, Your Lordship.
Sterling witness has been elaborately discussed in Rai Sandeep. Rai Sandeep perhaps has been quoted here. 9.3, para 9.3. Please see 9.3.
Yes, here you don't.
Who is said to be a Sterling witness?
Yes, sole witness.
Sterling witness. The reference is to a Sterling witness.
Yes.
Whose evidence is trustworthy, is
Yes.
convincing, is
Yes.
credible.
Yes. And here, in this case also, informant is a victim as well as second wife of the accused, mother of the child. Pulling and pushing may not lead to such a serious injury.
Yes.
Yes, that's all.
Anything to add, Mr. Tafu?
No, man.
We will try to consider.
Yes, man. What we have, so I just submitted, we will accession, it might be come to part 1, Malak. P04. Intention was not there.
with a feet of appellant. G. Tadu, APP. And D. Laji. Learned America Security for the number 3. Hearing is concluded, judgment is given.
I'm obliged.
How many single bench spent?
Single matter, there is only 15.
Okay, we'll see it in 5 minutes.
One of judgment, item number 15.
In the conspectus of the above discussion, this court is of the opinion that the impugned action is unsustainable in law and not in consonance with the objective of the Act of 2013. Accordingly, writ petition succeeds and the impugned revised estimate as contained in the award dated 14/2/2020 is interfered with and is set aside. Award is accordingly directed to be prepared in accordance with the communication dated so-and-so issued by the Deputy Commissioner Tawang to the Director of Land Management, whereafter expeditious steps be taken for release of the amount. Aforesaid exercise be undertaken and completed expeditiously and preferably within an outer limit of 90 days from the date of receipt of a certified copy of this order. Yes, Mr. Das.
I'm so sorry to mention one matter. If it is possible, my lord. Otherwise, I am here. No, item number 14, your lordship will rise at 2:45.
Yes, today there is some.
So this is your choice to recollect, it isn't fixed. Because this is what the state is going ahead. Because there was some order to be passed on the when it was moved.
It reaches, but the chances are less.
That's what, my lord.
If we will be here till it might reach also.
Yes.
Not too much matter, 14 matters.
Yes, yes. That's I'm here, no problem, my lord.
Lordship, I would like to mention item number 10.
Yes,
Lordship,
madam.
here we have to file affidavit, Your Lordship. Some time may be given, Your Lordship.
Matter of which year?
It's 24, Your Lordship.
Why is it for the orders? We have to check. Have you checked the records, court records?
Yes, Your Lordship.
You, what is it? Maybe for steps or something. There are other.
For affidavit only, Your Lordship.
Is it?
Yes, Your Lordship.
No private respondent.
No, Lordship.
Let's see the file, item number 10. Wait for a turn, madam. We will
Lordship.
grant you time. Don't worry. Item?
Item number 1,
Yes.
Lordship. Lordship, we would like to withdraw this matter, Lordship.
Is it? Why are you withdrawing?
Lordship, because the petitioner herein, they have filed one civil suit before the civil judge, Pasiga.
What is your name?
E. Payang, Lordship.
E. Payang.
Yes,
You are
Lordship.
not on record.
No, Lordship.
You are on behalf of whom?
Conducting counsel Galintalo.
Sri E. Payang, learned counsel appearing on instruction of Sri G. Talo.
Yes,
Lord. Counsel for the petitioner has submitted that there are instructions to withdraw the writ petition in view of the fact that the cause of action has been espoused in the appropriate civil court. Para. Also heard Ms. G. Ete, learned state counsel. Para. In view of the aforesaid submission, writ petition is dismissed on withdrawal.
Nice.
Item number 2 and 3.
2 and 3, 2 is of 21, all matters, 21 matter, 18 matter. What are these? Yes.
Lordship, I'm appearing in the writ petition, Lordship. Item number 2.
Yes,
Three parties are different, Lordship.
okay.
They are represented by
Why,
council.
why are these two matters connected?
Connected in fact, Lordship, during the pendency of this CRP number 12 of 20 AP of 2018, item number 5. During the pendency of item number 5,
Not 5, 3.
sorry, 3. Lordship, this there is a judgment and order passed by arbitration board that is put to challenge in item number 2.
You are challenging that.
That in spite of our repeated reminder to the arbitration board saying that CRP is pending before this honorable court, the arbitration board has passed that impugn order.
But CRP, you are not a party.
CRP, we are party, Lordship.
You are parties.
CRP, I am not a party. I have not been made it. I'm party, I think, Lordship.
Then how are you connected? Unless you are a party in the pending CRP, why should the arbitration be stopped? Mr. Yadav, you are for whom?
My Lord, I am appearing on behalf of Mr. Timeson.
T-Zone.
Yes, ma'am. Due to some personal difficulty, he could not come.
But these are all matters. We cannot adjourn these matters. These are very old matters.
Lordship, in CRP, I'm a party, Lordship. I'm on the respondent side, Lordship.
T-Zone appears for whom? For the respondent?
Yes.
In both the matters?
In item 3.
3. And 2? State is a party here. Madam?
No, sir.
When can Mr. Soon be back? Monday?
Yes, ma'am.
We'll have it on Monday.
Yes.
Okay. While JG General Counsel for the petitioner. And who's for in CRP? Who's the petitioner? You are there.
Number 3.
Whereas JG Leonard Counsel for petitioner and WPC 130 of 21 and 3. Where is Mr. Your name?
My name is
Ibam. Ibam. Leonard Counsel for petitioner in CRP 12 of 2018 are present. A prayer for adjournment has been made on behalf of Sri T-Zone, Learned Counsel for the respondent in the CRP. Para? Considering that these are all pending matters, while an adjournment is granted, the same are directed to be listed on Monday. Monday, don't seek adjournment.
Yes, ma'am.
Obliged, Lord.
For admission.
Item number 4.
I'm appearing for the petitioner on this.
Yes.
Yes. My Lord, on the last date of hearing, my Lord has just asked one specific question, and that was whether the Limitation Act 1963 is applicable to an application for appointment of an arbitrator, my Lord.
Yes.
Yes, my Lord. So, my Lord, my associate, there is a specific judgment, my Lord, in this matter on the issue that raised by my Lord. That is 2024 judgment. Messrs. Arif Azim Company Limited versus Aptech Limited, my Lord.
Yes. Authored by Justice Padiwala.
Yes, my Lord. Yes, my Lord.
Yes. Yes. That is the law. What has been laid down?
Yes, my Lord. So,
copy.
My Lord, I'm coming directly to page paragraph 44, my Lord. From where,
you have not given the list of citations to the court earlier.
My Lord, my associate is there. Yeah.
Huh?
No, she have not got any citation.
You have not given the list of.
I have given.
Whom did you give? You take care. Your matter has been taken up at 1 o'clock. Your matter, madam, you should be vigilant.
I'm so sorry,
Pick
my
out the
Lord.
books in advance. So there you should take care. Page,
My lord, in the paragraph 45, my lord, I'm coming straight to
page,
paragraph.
page.
My lord,
We give the citation again. 2024. 5 SCC. Please give the citation again. Mr. Prakash, please give the citation again.
My lord, actually, I'm reading directly from the Supreme Court website, my lord, this judgment, my lord. So, I
No,
mean, my
your
lord is
citation, 2024. 5 SCC.
2004, 5 SCC.
5 SCC.
Yes.
Page? Page?
313. 313.
313.
Yes.
the law is started, my lord. The Honorable Supreme Court has discussed the law in length, my lord, from page, in paragraph 45, my lord, in this judgment. Have you got that, my lord?
Yes.
Yes, my lord.
How does
May I
it
read, my
start?
lord, paragraph 45?
How does it start?
The plain reading of section 11, subsection 6 of the Act 1996.
Your paragraphs will be different. You are not, we are having the SCC. Plain reading, 46, yes, 40, it may be 46, yes.
Okay, my lord.
46.
Plain reading of.
It is a discussion under issue number 1.
Yes, my lord. That is the specific question my lord had asked on the last hearing, my lord.
Yes, yes.
Whether the applicability of Limitation Act and the arbitration, my lord. So, my lord,
yes.
yeah. So the Honorable Supreme Court has said the plain reading of section 11(6) of the Act 1996, which provides for the appointment of arbitrators, indicates that no time limit has been prescribed for filing an application under the said Act. However, Section 43 of the Act 1996 provides that the Limitation Act 1963 would apply to arbitration as it applies to the proceeding in the court. So then after, my lord, they have discussed Section 43, that is limitation. So Limitation Act shall apply to the arbitration as it applies to the proceeding of the court, my lord. Then after, my lord, the next paragraph, that 47, I think, my lord, in your book. Yes, my lord. Since none of the articles in the schedule to the Limitation Act 1963 provide a time period for the filing an application under Section 11(6) of the Act, it would be covered by Article 137 of the Limitation Act, which is the residual provision as it is under, my lord. So, my lord, there's a table it is given, my lord. So, any other application for which no period of limitation is provided elsewhere in this division, period of limitation is 3 years, my lord. And when the right to apply accrues, my lord. Then, my lord, I'm coming straight to the paragraph 53 in your book, my lord.
Yes.
Yes. So it is held in catena of decisions of this court that the limitation period for making an application seeking appointment of arbitrator must not be conflated or confused with the limitation periods for raising the substantive claims which are sought to be referred to an arbitral tribunal. The limitation period for filing an application seeking appointment of arbitrator commences only after a valid notice invoking arbitration has been issued by one of the parties to the other party, and there has been either a failure or refusal on the part of the other party to make appointment as per the appointment procedure agreed upon the parties, my lord. So, my lord, after discussing this, my lord, I'm just coming to the final part, that is at paragraph 91, my lord, because that applies to our case, my lord.
Yes.
Yes, my lord.
Yes, please.
One. 91. Yes, my lord. So, it's from 90, I'm reading, my lord. I mean, if my lord is there. My lord, thus from the exhaustive analysis of the provisions of law on the issues, we are on the view that while considering the issue of limitation in relation to the petition under section 11(6) of the Act, the court should satisfy themselves the two aspects of the employing the two prolonged tests. First, whether the petition under section 11(6) of the Act is barred by limitation. Second part, whether the claims sought to be arbitrated are ex facie dead claims and are thus barred by limitation on the date of commencement of the arbitration proceeding. If either of these issues are answered against the party seeking referral of disputes to the arbitration, the court may refuse to appoint the arbitral tribunal. So, my lord, this 91 is very important, my lord. Para 91, that is the conclusion under the heading of conclusion, my lord. So, my lord, the present application proceeding have been filed within period of 3 years, from which the date when the period the respondent failed to comply the notice of invocation of arbitration issued by the petitioner is not hit by the limitation, my lord. So, this part is very important, my lord. Once we send the notice to the other party, my lord, and the other party.
When did you say? When did you send the notice?
In 2017 December, my lord.
Please give the date.
Yes, that is date is, my lord, 26th December 2017, my lord, at page 122. My lord, before that, I would like to why this notice was sent, my lord. The simple background, my lord, of this notice, because that is also very important, because cause of actually arose at that point of time, my lord, because the respondent number one, my lord, can have the affidavit filed by the respondent number one. That is at page 5 of the affidavit, my lord.
So we'll continue at 2 o'clock. Okay. That's 2 o'clock. But we'll have to rise early today. So.
All right, my lord. I'll join at 2 o'clock, my lord. Otherwise,
No,
my lord, my 2 minutes.
No,
my
your
lord,
matter
more.
will be over. Your matter will be over, but other council, all the matters will not be able to be completed with this.
Then we'll take tomorrow, my matter.
Tomorrow. Let us wait for the last moment.
Yes, yes.
My lord, with due permission, my lord, item number 8, my lord, it will take time, my lord, sometimes, half an hour minimum, my lord. It's a standard matter, my lord.
Do it for the other side.
Mr. Deep Hanging right now, he's in a meeting, my lord. If we have both agreed for 3rd of March, my lord.
Okay, today it may not be possible.
Yes, my lord, that is the reason, my lord.
Meeting of Lokayukta.
Yes, my lord.
Bar is also involved, I think.
3rd March, 8 and 8.
Can we put as a joint request?
Yes, joint request.
On a joint request, on a hard, we will record your name. Hard, Sri Panging is there?
Panging is there.
Hard Sri D. Panging, learned counsel for the petitioner, as well as Sri B.K. Singh, learned counsel for the FCI.
FCI, my lord.
Kato is there for the Union of India?
Yes, my lord.
Sri M. Kato, learned deputy HJ, is present for the Union of India. Para. On a joint request, matter is adjourned to be listed on 3-3.
All right.
Well, item 11, it's a lot, it's not in a position to take up. Can it be fixed on 25th month?
25th month. Mr. Panging?
We have, he has told us any date next one should be informed. We have informed.
You are for whom, Mr.
I am for the petitioner.
11.
My.
Sri D. Mazumdar, Ranat Senior Counsel. I don't know, paucity of time may not permit, but it is for orders. Why is it for orders?
Well, it's actually for revision of final disposal.
Maybe it's for some steps or something. 23 respondents.
Well, affidavits have been exchanged already.
And what about the private respondents? 23.
Mr. Pangi is appealing for all the private respondents.
Okay. I heard Sri D. Mazumdar, Learned Senior Counsel for the petitioner. Also heard Sri L. Parme. Which department, Mr. Mazumdar?
Power department.
L. Parme. Oh, yeah, yes, power department. And Sri D. Pangi, Learned Counsel for the private respondent.
All right.
Paucity of time may not permit the matter to be taken up today. On request, list on
25th month.
25-2
my lord. For admission, my
for admission.
lord.
Yes. Yes, Mr. Prakash, where are you?
Please, my lord. Yes, my lord. So, my lord, as we discussed in this judgment, my lord, so
Yes.
so far as limitation is concerned, very much applies to the Section 11 petition, my lord. And all we need to send one notice, my lord, to the other party for invocation of the arbitration proceeding, my lord. And that notice was sent, my lord. Before I'm coming to that notice, my lord, it is very important, my lord, that when that actually the cause of action accrues, I mean, as per Article 137, my lord, as discussed in the judgment. So, my lord may see the affidavit filed by respondent number 1. If my lord can get that.
Page
5 of that affidavit, my lord.
Internal page
5, my lord. Internal page 5 of that affidavit filed by respondent number 1. That is affidavit in opposition filed by respondent number 1.
paragraph.
Paragraph 8, my lord. My lord has got that? Yes, my lord.
Yes.
My lord, we are just skipping 6 lines from the above. That paragraph starts with pursuant to such petition, my lord. I think we are
There to
pursuant to such petition.
there.
Yeah.
No, you are on which
So
page?
I'm just skipping 5 or 6 lines above. I'm coming after that to that pursuant to order dated 26th June 2027.
No, you are on which?
That is affidavit in opposition filed by respondent number 1, my lord.
Paragraph?
Paragraph 8, my lord, at page 5. Page 5 of that affidavit.
It is Roman 6, I think.
No,
Isn't it Roman 6? Pursuant to such petition.
No, most of it's paragraph 8 first. Paragraph 8. Page 5.
Page
Nine
5.
of the reports.
What is the running page, madam?
Running, it's also this. Page 5.
No, running page.
Those times.
Running pages are there. So the petition is goes so many pages.
Contract is. In this process, there is no running record.
Madam, you have to check the records before you make a submission. You are simply saying will not do. The running pages have been given. You have not matched your file with the court records. No, we'll find it out. Don't worry.
Yes.
Oh, you're correct. You're correct. This madam is correct. This petition starts is up to how many pages? 138.
Yes, Lord.
Thereafter, yes, you're correct. There's no running page. This is by the respondent number 1.
Yes, my lord.
Yes.
This is an affidavit in opposition file on behalf of respondent that titled as. Yes, my lord. So, my lord. Paragraph
Page
8, my
5,
lord, at page 5, my lord. So, my lord, I'm skipping initial 6 lines, my lord. Then, my lord, I'm reading that pursuant to order dated 26 June 2017, my lord.
Yes.
Have you got that, my lord?
Yes, yes.
Yeah. Suda, that is respondent 1, my lord.
Yes.
Has issued an order dated 16th November 2017, directing the petitioner herein to refund a sum of rupees 3 crore 61 lakh rupees something, my lord. So this order actually initiates the cause of action, my lord. Yes, my lord. Subsequently, my lord, we replied to this particular letter by our reply is at 122. That is also for the appointment of request for the appointment of arbitrator, my lord.
Page
Page 122, my lord.
of your petition.
Yes, my lord. That is this letter dated 26th December 2017, my lord.
Yes.
Yes, my lord. Before going into a lot of correspondence, it has mentioned from right from page 21 to 2, my lord. I'm coming straight to 124, last paragraph, my lord. Sir, 124 last paragraph. You got that, my lord?
Yes.
Yes, my lord. So I'm allowed to read, my lord, this paragraph. Sir, while
Yes.
taking any decision, kindly go through the contents of the above said letter. Our motive was to establish a EWS and affordable colony for the general public in Itanagar as pursued by the housing department. In accordance with the assurances given by the department, we have invested huge amount. Our intention was not to run away or close the project, but to duress circumstances have accepted order of the department for closure of the
Where, Mr. Prakash, where are you reading? Which page?
124, my lord. Yes, my lord.
124.
Yes.
124. Last paragraph.
Yes, my lord.
Sir, while taking any decision, this is one.
Yes, my lord. Yes, my lord. So while
Please
taking
read
any
why.
decision, kindly go
Yes.
through the contents of the above said letter. Our motive was to establish a EWS and affordable colony for the general public in Itanagar as persuaded by the housing department. In accordance with the assurances given by the given by the department, we have invested huge amount. Our intention was not to run away close to the project, and under the duress circumstances, we have to accept that the order of the department for closure of the project, since local people application are pressurizing for refund of their money, as the project was delayed due to the sluggish approach of the department and not the adhering to the commitments made by them. So the letter says that the SUDA has made certain commitments, my lord, that they have not actually fulfilled those commitments. Because of that only this project has been delayed. Then, my lord, I'm coming to 125 page number, my lord. That we had to suffer heavy losses on the account, as we again assured by the department. We had handed over the possession of the land in question along with the structure for the sale and repayment of the prospective buyers. You are requested by the last paragraph, that is, you are requested to kindly look into the matter and give us a justice. As requested, the matter may be referred to arbitrator Dean Friedman. So this letter clearly says that we requested the respondent 1, my lord, for the appointment of arbitrator, my lord. And subsequently,
Yes.
but the respondent 1 did not pay any heed to that letter, my lord. So that is the last communication, my lord, more or less. So, my lord, as we discussed in the judgment, the 3-year limitation accrues from the date of the letter for appointment of arbitrator, request letter of arbitration, arbitrator appointment, my lord. So, taking that letter 27th December 2027, my lord, 2017, my lord. From there, so 3 years. So 3 years that ends in 2020, my lord. So, but during in 2020 March, my lord, the COVID came, and subsequently, my lord, Honorable Supreme Court in suo motu writ petition, my lord. Suo motu writ petition number 3 of 2020, my lord, that was widely circulated in all high courts also, my lord. So in that, the Honorable Supreme Court extended the limitation period, my lord. So that went to 1st March 2022 and plus 90 days, my lord. So calculation we have already discussed. So our petition is almost within limitation, my lord. Even few months are still remaining when we file this petition, my lord.
When did you file this petition?
Yes, we filed this petition 31st March 2022, my lord.
Okay.
Yes, madam.
Yes, madam.
Lordship, the limitation period, Lordship, 3 years is already clarified by my Dushan Lanet.
Do you appear for sole respondent? How many respondents are there?
No, Lordship, 2 respondents. I am for 1. Lordship.
Who is two?
The landowner, my lord, on which that project was constructed.
Lordship, but then so far my instruction, Lordship, we are, it's Lordship, this one is, we are taking it 2014, when they had stopped the construction and they just abandoned and they left the place, Lordship, to Canada.
That was in 2014.
May 2014. The work started in November 2011 and they just stopped and abandoned it in May 2014.
Okay.
And Lordship, one more thing in memorandum of understanding in petitioners, Lordship, annexure itself, Lordship, page 76, Lordship. Lordship, if your Lordship come to page 76, para 22, Lordship, paragraph 22. Lordship, may I get Lordship? Lordship, it says here that except as otherwise provided in this MOA, all questions and dispute related to the meaning of the specifications, designs, drawings, and instruction herein mentioned, and as to things whatsoever in any way arising out or relating to the agreement, designs, drawings concerning the work or the execution or failure to execute the same, whether arising during progress of the work or after the completion or abandonment thereof, shall be referred to the technical wing of Department of Housing, Dr. AP Sudha, in writing for his decision within a period of 30 days of such occurrence. Thereupon, the technical wing of Department of Housing, Dr. AP Sudha, shall give his written instructions, decisions within a period of 60 days of such requests to the builder and engineer in charge. This period can be extended by mutual consent of the parties. Upon receipt of the written instruction or decision, the parties shall promptly proceed without delay to comply such instruction or decision. If the technical wing of Sudha fails to give its instruction or decision in writing within a period of 60 days or mutually agreed time after being requested, if the parties are agreed against the decision of the technical wing of Sudha, the builder parties may within 30 days prepare an appeal to the Department of Housing of AP, who shall afford and to offer evidence in support of their appeal. The Department of Housing, Dr. AP, will give its decision within 30 days. And if any party is not satisfied with the decision of the Department Housing, Dr. AP, it can refer such dispute for arbitration. Arbitrator tribunal constituted ACA Act, AC Act 1986. This has not been fulfilled by the respondent person, the applicant here first. No such lawsuit. A parties agreement lawsuit. That this thing has to be referred to the technical wing department lawsuit. And there has to be a submitted lawsuit accordingly. This has not been followed and lawsuit. I'm also relying upon the which I had last said lots of Bharat Sansar Nigam Limited Parshad NS Norton Networks Private Limited lots of. There also BSNL issued an NIT lordship, wherein Nortel participated and was awarded the purchase order lordship. And then lordship, there was a dispute where the Nortel lordship raised claim lordship na 13/5/2014. On 13/5/2014, BSNL rejected the same on 14/4/8/2014 lordship. And then Nortel lordship filed an application before the lordship, Kerala High Court lordship, for appointment of arbitrator lordship. And then this application was allowed. That against that lordship, the BSNL filed a review petition before the same lordship. This High Court lordship, Honorable High Court lordship, and then that was dismissed. Against this civil, he was prepared by the BSNL before the lordship.
What has been held here?
So here lordship, it has held that lordship. Lordship, I'm
Para?
lordship 13, 15, 16, 17, 38, and 39. Finally, lordship, the set aside it was 13 lordship.
Yes.
Dr. Thakur says, Dr. Dennis, High Court have taken the view that Article 137 of the limitation would be applicable to an application under Section 11 of the Arbitration Act. The question of the applicability of Article 137 to applications under Section 11 of the 1986 came up for consideration before the Bombay High Court in this Packet versus Municipal Corporation lawsuit, 2010. So and so. Wherein it was held that the period of litigation for an application under Section 11 would be governed by Article 137. Since subsequently in the so and so also, the Bombay High Court framed the following issue. Article 137 of the schedule to the limitation of 1963 would apply to the arbitration application filed under Section 11(6) of the Arbitration Act, and it applies whether Section 5 of the limitation of 1963 would be applicable to this arbitration application, and if Section 5 applies to this arbitration application, whether the applicant has laid out a sufficient cause for condemnation of delay in filing this arbitration application. I'm not here, the Bombay High Court held that, in my view, since the proceedings under Section 11(6) of the Arbitration Act are required to be filed before the High Court, Article 137(7) of the schedule to the limitation of 1963 would apply to such application filed under Section 11(6) of the Arbitration Act. In my view, since the Article 137 of the schedule to the limitation Act 1963 would apply to the arbitration application under Section 11(6) of the Arbitration Act, Section 5 of the Arbitration Act 1963 would also apply to the arbitration application filed under Section 11(6). And lawsuits, that paragraph 15 lawsuit here it says the reasoning in all those documents seems to be that since an application under Section 11 is to be filed in a court of law, and since no specific article of limitation of necessary applies, the residual article would become applicable. The effect is that the period of limitation to file an application under Section 11 is 3 years from the date of refusal to appoint the arbitrator, or on expiry of 30 days, whatever is earlier, says And Lordship 16, 17, I will already rendered it. I would like to Lordship read out 39. 38, 39.
39.
38, Lordship. 38 here, this is regarding this case, Lordship. Applying the law to the facts of the present case, it is clear that this is a case where the claims are expressly time barred by over 5.5 years. Since Norton did not take any action whatsoever after the reaction of his claim by BSNL on 4/8/2014, a notice of arbitration was invoked on 29/4/2020. There is not even an amendment either in the notice of arbitration or the petition filed under Section 11 or before this court of any intervening text which may have occurred, which would extend the period of limitation falling within Section 5 to 20 of the Limitation Act, unless there is a bigger case specifically adverting to the applicable section and how it extends the limitation from the date on which the cause of action originally arose. There can be no basis to save the time of limitation. In 39 Lordship here, the present case is a case of dead with no successful dispute since the court of action arose on 4/8/2014 when the claims made by Norton were rejected. The respondent has not stated any event which would extend the period of limitation which commences as per Article 55 of the Schedule of the Limitation Act, which provides limitation for cases pertaining to breach of contract immediately after the reduction of the final bill by making deductions. In the notice in booking arbitration dated 29/4/20 has been about that various communications have been exchanged between the petitioner and the respondent ever since any dispute has arisen between the petitioner and the respondents regarding non-payment of the amount due to tender document. The period of limitation for issuing notice of arbitration would not get extended by mere exchange of letters. Also, this is in SS Tata versus so and so. So accordingly, Lordship is here in this case also Lordship. Since they have come after 5.5 years, Lordship.
But Mr. Prakash has submitted that the order by the authority for refund, demanding refund, was made on 26/6/2017.
That is in record.
So if that is held to be a cause of action, then he is saved by limitation. 26/6/2017, and thereafter he had issued notice for arbitration on 26/12/17.
Yes, sir.
And he has also tried to bring in the exemption given by the Honorable Supreme Court in the Sumoto case, 3/20, extending the limitation up to 1/3/2022 plus 90 days.
That is right.
So, Madam, if you allow, we have to appoint an arbitrator. Who is there any designated arbitrator for this matter?
If the limitation period Lordship is
If we hold in favor of the petitioner, then we have to appoint. Do we have a panel of arbitrators?
Any,
Or is it covered by the contract holding the field?
no, my lord. My lord, my humble submission, any retired judge of this honorable High Court, my lord, that will be better, my lord. Well, for fair adjudication of the matter, my lord.
No, does this? Where will be the seat of the arbitrator?
My lord, we will prefer, sir, Guwahati, if my lord can, because their seat is not mentioned in the arbitration agreement, my lord. So this is why, my lord, my humble submission, if possible, my lord, any high judge, from Honorable High Court retired judge, my lord, who can conduct arbitration proceeding in Guwahati, my lord. That will be, my humble, my lord, less, my lord.
Madam, though this is a panel of arbitrators, we are not supposed to be restricted to only this choice. We can have any other retired judge of the High
Yes, my
Court.
lord. Yes, my lord.
Can I have a consultation with my husband?
Please do. Please do. Please do. Tentatively, we can inform you that we'll allow this petition. Will not held this petition to be barred by law of limitation. Then in that case, you need to, Mr. Prakash has said, any High Court, retired High Court judge, there's a panel, 3 members are there, but there are many other retired judges. And taking into consideration the dispute involved, you take instructions, we'll allow this petition and will, but provided the honorable retired judges is ready, I think there should not be any difficulty. Okay, we'll pass appropriate orders, okay?
Here I am respondent number 2. So this dispute regarding this dispute which I argue today is between the respondent number 1 and the petitioners. So my name has been honestly there. There is separate agreement between me and the company. So they have abandoned the project. Then there was some enforcement by so many people.
Yeah, item number
4.
Mr. Tarak, you are for R2.
R2, yes. I am the landowner.
You say you are not connected with the dispute.
I have the different agreement. And they abandoned the land. So many 300-400 people they encroach upon them. I have to fight so many battles with them, and I have chased them out. The land is with me. This is the respondent number 1 as well as the applicant they run away. Since 2014, they have abandoned the land. So there is a condition that if there is, due to some major, condition number 10 of my agreement is there. So I have terminated the.
You have agreement with whom?
I have agreement with this company, applicant. Now, present dispute arises, the government have to repay those people who booked the flat. They have to repay. Now that government says that this has to be recovered by the company. Then they have dispute arises. I am not connected to that extent.
Who are you? You are the landowner.
Yes, I am landowner. I have agreement with the company that they will construct a housing complex there.
Colony.
Yes.
But
they have utterly failed and they have run away.
May I submit, my lord, if he,
Yes.
if anything more has to, Mr. R2 has to say, then my lord, I'm just waiting. Otherwise, may I submit on this regard? Yes, my lord.
No,
So far as
yes.
R2 is concerned, my lord, of course there is a separate agreement, my lord, between the petitioner and R1 and R2. Separate, both have the arbitration agreement, my lord. So, but however, my lord, the land on which this entire project was supposed to be built, that land belongs to R2, my lord. And what was promised in our agreement, the delivery of land was not in consonance with that agreement, my lord. Because of this was one of the factors why this project has not actually been successful at that point of time, my lord. So this is why now that R2 cannot say that I am having a separate agreement, I cannot come, I have no issues. I mean, this dispute is with my petitioner and R1, my lord. They are very much part of this. and they have taken the payment of the entire land twice before terminating this agreement unilaterally, my lord. So they have
No,
sold
the-
it
the-
for-
So you
Yes,
can
my lord.
have
So these are the
Prakash,
Yes.
Mr. Prakash, these are on merits of the dispute.
Yes, my lord.
The merits of the dispute will be taken up by either of
yes,
the
yes, my
parties.
lord.
Where he can say that he is not connected. We are only on the aspect of
On the legal point,
appointment of arbitrator.
yeah,
Okay.
on the
We'll pass
legal-
it.
on the law point, my lord, so far as he said that I have because two separate agreement whether one arbitrator can be appointed, my lord. There was a famous case, my lord, Dr. P.R. Shah, my lord. In that, Honorable Supreme Court has clearly said that if the two parties are internally engaged, my lord, even if the two separate agreements are there, one arbitrator will be appointed, my lord. That
No,
is civil.
but your dispute presently is with the respondent one.
And because
If you say that the cause of action has arisen by the
Yes,
refund notice,
yes, my lord.
then we'll confine our dispute to the respondent
Yes, my lord,
one.
no problem.
Where you
Whatever,
can
my lord,
also raise your dispute with the respondent two. Yeah, it's up to him to say it's a separate argument.
Yes,
Okay, we'll pass appropriate orders. Okay.
all right, my lord. Oblige, my lord. Thank you very much, my lord.
Which pass the order right now? No? It's up there. The instant application has been filed under section 11 within bracket 6 of the Arbitration and Conciliation Act 1996 for appointment of an arbitrator. Full stop. I have heard Sri A. Prakash, learned counsel appearing online. I have also heard Ms. G. Ete, the learned state counsel appearing for the respondent number 1, and Sri G. Tarak, learned counsel for the respondent number 2. Full stop. Para. Sri Prakash, the learned counsel, has submitted that though the work connected had started in November 2011, due to certain factors beyond the control of the applicant, the same could not be carried out. Full stop. He has drawn the attention of this court to a communication dated 26/6/2017 issued by the respondent number 1 demanding refund of a huge amount, which was replied to by the applicant. Full stop. Reference has also been made to a communication dated 26/12/2017, whereby a request was made for adjudication of the dispute through arbitration, which was a part of the agreement. Full stop. He has added that if the notice seeking arbitration is taken to be the date from which the Limitation Act would apply, comma, the limitation would be there till 25/12/2020, full stop. However, in between, comma, there was the intervention of COVID-19, and the Honorable Supreme Court in 2003 of 2020 had extended the limitation up to 1/3/2022 with additional 90 days. Full stop. He has submitted that the petition present application was presented on 31/3/2022, which is within the period of limitation. Full stop. The Learned Council has relied upon the case of Arif Azim reported in 2024, 5 SCC 313, and the following observations made by the Honorable Supreme Court are pressed into service. 46, 53, 92, 93. Okay. Per contra, GAT, the learned State Council has submitted that normally in an application for appointment of arbitrator filed under section 11 of the Act, there is no resistance, full stop. However, the instant application is barred by time as the cause of action had arisen sometime in May 2014, full stop. She has submitted that a work was allotted to the applicant in November 2011 and abruptly the work was stopped and the applicant had left the place of work at Itanagar, full stop. She has also drawn the attention of this court to clause 22 of the agreement and has contended that unless the said condition is fulfilled, an arbitration cannot be demanded. She has submitted that in any case, the application which was presented on 31/3/2022 is beyond the prescribed period of limitation of 3 years as provided in Article 137 of the Limitation Act. Para 3 Tarak, Learned Counsel for Respondent 2, has submitted that the present dispute is not connected with the Respondent 2, who has been unnecessarily added as party. He has submitted that he represents the landowner he represents the owner of the plot of land over which the housing colony was to be constructed, for which there is a different agreement with the applicant. Para. The rival submissions have been duly considered. Para. The aspect of applicability of the Arbitration Act, of the Limitation Act 1963, with an application seeking appointment of arbitration has been settled by the Honorable Supreme Court in the case of Arif Azim, the relevant observation having extracted above. Full stop. Para. The Honorable Supreme Court in the aforesaid case has discussed that since there is no articles in the schedule of the Act, an application made under Section 11 of the Arbitration Act would be covered by Article 137 of the Limitation Act 1963, for which the limitation has been prescribed as 3 years from the date when the right to apply accrues. Full stop. In the instant case, a cause of action can be said to have arisen by the communication dated 26/6/2017 issued by the Respondent number 1 demanding refund, which was replied to with a request for arbitration made on 26/12/2017. Full stop. If the Limitation Act applies from 26/12/2017 vis-a-vis the date of presentation of the instant petition on 31/3/2022, wherewith the orders of the Honorable Supreme Court in suo motu 3 of 2020, the instant application appears to be within the period of, it appears to have been filed within the period of limitation. Full stop, para. The objective of an application filed under Section 11 of the Arbitration and Conciliation Act is for appointment of an arbitrator and not for any adjudication of the dispute on merits. Full stop. The Honorable Supreme Court has, however, made certain observations that such application should not be made where for debt claims, DEA, the debt claims, which does not appear to be applicable in the instant case. Para, in view of the aforesaid discussion, the present application is allowed, full stop. This court accordingly appoints. Yes, madam, have you taken any? You're supposed to take instructions. Appoint, we'll put the name, okay?
Yes,
We'll put the name, we'll try to get some
Yes.
consent from the registry. Appoint Honorable Justice so-and-so, former judge of the High Court, to be the arbitrator. Full stop. The seat of the arbitrator may be at Guwahati, which would be convenient for both the parties. Full stop. The learned arbitrator may accordingly fix the dates for commencement of the same in accordance with law. Okay.
Okay.
Yes. Okay, Mr. Das, not person. Mr. Purkas, to which matter?
My lord, item number 12, the contempt matter.
And the Gogoi? Gogoi for which matter? Gogoi, you are not audible. You have to unmute yourself.
My lord,
Item 7. Item
We
7.
have to give dates.
My lords.
7 is connected with 6, I think.
Yes, my lords. In but 6 we have not received anything. In 7 notice has been issued to the chief secretary, my lords.
You are for whom?
I am for the chief secretary, my lord. State of Assam has been arrayed at 6 and 7. And the deputy.
Have you filed affidavit?
No, my lord, we will file affidavit, my lords. First time we appeared.
You have you haven't.
He's appearing for the first time.
Appearing for the first time.
Instead of appearing for respondent number 4 and 5. I filed my affidavit in opposition yesterday.
You are making the submission 6 and 7.
6. No, 7, my lord.
And 6, who is for 6?
I'm for 6 and 7. Chief Secretary and the Deputy Commissioner Dhemaji, my lords.
Okay. 3, D. Gogoi, learned counsel appearing online for the Chief Secretary.
Additionally, G.
D. Goswami, so D. Gogoi, learned counsel appearing online on behalf of Sri P.N. Goswami, learned AAG, Assam, for the Chief Secretary, Government of Assam, and the
Deputy Commissioner Dhemaji, my lords. Deputy Commissioner Dhemaji.
Praise form, and is granted 3 weeks' time to file the affidavit in opposition. Sri R. L. Tungan, Senate Counsel, for the respondent number
4 and 5 in item number 7.
Appearing in item number, appearing in WPC 139, 2025, has informed that affidavit in opposition has already been filed. Tara, please put the matters after 3 weeks, by which time further will be exchanged.
My lord, in order column, because
Mr. Das,
Can this matter be taken up tomorrow, my lord?
which one?
Last item that your lordship has fixed this matter, 14.
Tomorrow we'll fix matter.
There is some urgency in this matter
Tomorrow.
because there is some zero. Your lordship just recollect that my land has been using and this particular jirat. Now, if they use my land, nothing remains.
Early, because tomorrow it may not be possible. Monday will you be there? Monday?
My lord, if your lordship kindly, my lord, if it is possible.
Tomorrow will not be possible.
Tomorrow I'm here. So tomorrorow I'm here.
Tuesday you can say whatever date. Item number 14.
14, because there was,
Paucity of time
but they are going ahead.
would not permit
My lord,
the
they,
matter to be taken up today. Sarah, as urgency has been expressed
18,
by
right.
Sri Lee Das Learned Counsel for the petitioners. List for consideration on Monday or Tuesday, whichever. Tuesday is the division bench. I think Wednesday, 18th. Will you be there? 18th. 18th.
There is some, my lord, if it is on top of it, because there was some urgency, they are going ahead.
18th. The petitioner is at liberty to make a mention of this matter for upgrading the center.
They are going ahead with nothing will remain, my lord. There's a,
Item number 5 may be taken up on Monday.
Monday, okay, she'll give date. Okay, we have to write.